property.
Did the judge make a comment about, and the buzzwords here are credibility? The judge found one expert to be more credible than the other expert. Is that correct?
I can't say that he specifically stated the words credibility on the record. However, he did say specifically that he did not find Mr. Carter's valuation as to specific comparable properties to be something that he agreed with, that he could tell by looking at the comps on his own that the property was not worth what Mr. Carter was claiming that it was worth.
Did he also examine, I guess, and evaluate the credibility of the parties? And specifically, I'm talking about your client, Ms. Houston, words to the effect of, we're all good now, the relationship is all good, we're not having any problems here. But the trial judge was presented with evidence which included your clients cutting off the power to some of the structures on the other side of the property, and the fact that there was some type of a drainage issue with regard to the pond, which resulted in the drainage. Similarly, the rent wars would be, I guess, dependent upon Ms. Houston and her conduct with regard to draining of the pond. Is that correct?
That is correct. However, the drainage could easily be redirected. So the fact that the drainage right now crosses in a manner that would be on the Rentmore's property does not mean that it couldn't be corrected in the final determination about where the property line should go.
But that would also be a consideration, right? You're making it sound like it would be very simple to divide the property, but there's these logistical support problems that are going to have to be worked out in order to divide the property. Would that occur before or after the division?
During the division, if your honors were to remand this, a special commission panel would be appointed who would decide exactly how to divide that property and would make those determinations. So that would happen at the next round in front of the commissioners. And just as in Schroeder v. Lawhorn, there are times when you're dividing the property that you have to create these logistical changes to the property. That doesn't take away the sacred presumption that the property should be divided.
I guess I have one more question, too, with regard to Mrs. Houston's conduct. Was there an event, I believe, in the facts of this case, where Mrs. Houston parked her RV or an RV in the common driveway, which resulted in some video cameras being pointed directly at the Rentmore's property? Are those facts of this case?
I don't recall an RV being parked there. There was definitely testimony that she had parked her truck in a manner that they thought impeded their ability to use the driveway, which would be alleviated by ordering, when you divide the property, that the other driveway be used by Ms. Houston instead of the shared driveway. The evidence that I recall about the RV is that the RV is actually parked on an adjacent lot to Ms. Houston's property, which is another factor that the court overlooked. If the property is not divided, then the adjacent lot to this one big parcel will have no access to the road.
Did the judge, I mean, I know that's one of your arguments, that the judge gave no weight to that and that's part of the error that you argue should justify the reversal and remanding here. But I mean, at the end of the day, didn't the judge say in the judgment that basically, even if I take that into consideration, it doesn't change the result here? So why, I mean, for example, or by analogy, you know, when I was a judge on a felony docket, you know, one of the things you'd have the score sheets as to the sentence points. I always made it a practice of saying, for the benefit of, you know, these geniuses up here at the 5th DCA, I always made it a practice of saying, look, even if there's any error in the score sheet, it's not going to affect the sentence that I'm about to impose. How is that not analogous here to the scenario saying, look, I don't think I should consider it at all. If she wanted to buy a landlocked property, that's between her and whoever. But even if I should consider it, it does not affect the overall decision here. Doesn't that make it if it's error, doesn't that make it harmless?
I don't believe so, Your Honor. I do think the situation is analogous, but the reason it's different in this circumstance is because this court, the lower court, was predisposed before any evidence to find that the property could not be divided due to the parties' relationship. And what I would argue, Your Honor, is that he came in with that predisposition.
What makes you suggest that from the record?
On page 12 of the record of the transcript on April of 2021, before opening argument, the court said specifically, I'm hard pressed due to, we had submitted a statement of facts, a joint statement of facts, that indicated exactly what the parties' relationship was. After reading that joint statement of facts, and before we ever made any opening argument, he said specifically, "I'm hard-pressed to figure out how these people should remain neighbors due to what I've read in the statement of facts." That's problematic for two reasons. One, the fact that you order the property divided is not the same as ordering them to remain neighbors. What it allows them to do is choose how to deal with their property independently of one another. If you divide the property, Ms. Houston can choose to stay in her house, or she can choose to sell it. If you divide the property, the Rentmores have the same option. Here, with the sale, the parties are now all being forced to sell the property. No one is being allowed to retain their rights, and this overlooks the fact that the Rentmores, the only substantial competent evidence in the record as to the division of the property with the resulting lots, would be that the Rentmores would have a lot that was worth approximately $320,000. Even accepting their expert testimony, Mr. Carter, that the property was worth $650,000, that's only a $5,000 difference between the total value of the property, accepting his opinion, and the only evidence as to the value of the resulting parcel. So there's no concern that needs to be dealt with in terms of will they be prejudiced if it's divided because they would remain neighbors. They can sell their lot and still receive the exact same value. And that's the position they're in now, is they're either going to sell the total property or they're just going to sell their lot. The evidence was clear that they wanted to sell the total property because they're hoping they can swoop in, buy the entire property, and buy Ms. Houston out so that she loses her interest in her homestead property. The other reason that the court's statements were problematic as to telling us in advance of opening argument that he didn't see any way that the property could be divided because he didn't want them to remain neighbors, shows that he was using the wrong presumption. The presumption is that the property should be divided unless there's prejudice shown.
But didn't the judge, though, then say in the judgment, even considering the statutory presumption of divisibility, the burden has been met by the Rentmores, excuse me. By the way, how do you say your client's last name? It looks like Houston.
It does look like Houston. It is Houston. And the Rentmores are the Rentmores.
All right. Yeah, so if anything, I'll get that right before this ends here.
He did say that in the final judgment, Your Honor, and that's problematic because the final judgment is simply a 21-page word-for-word adoption of the appellee's.
Well, I know you're unhappy about that, but I mean, and I know one of the supplemental authorities that you are correctly moving to strike was something that I wrote that talked about Perlow. I actually still remember it. I wrote it last year. So it wasn't there time, though, for you to object or do whatever when that proposed judgment was submitted to the judge. So, Perlow in those cases is the judge signed it, hours after it was submitted.
Yes, Your Honor.
Is that the distinguishing event here?
No. Here, the court specifically found at the end of the presentation of evidence that he was inclined to order the sale due to the parties' relationship. He then said, to the extent you want to try to change my mind, I will allow you to submit proposed findings of fact and conclusions of law, which is the task we went down. He said, before even doing that if we chose to do that, we would be giving the Rentmores a free hand on writing what the final judgment is going to be. That's the record at 611. That shows specifically that he delegated his judicial authority to the Rentmores and was going to accept whatever they submitted, which is exactly what happened here. At the time that we submitted them, we were properly preserving all of our arguments and objections to what had gone on and to his...
Did you move for a rehearing after that happened?
We did not move for a rehearing after that happened, Your Honor, because we didn't think that the final judgment was supported by the substantial competent evidence of the case. All the substantial competent evidence of the case showed that the value of the property as a whole is less than the value if it was divided, that the property was Ms. Houston's homestead property, that the Florida Supreme Court at Tullis v. Tullis in Note 2 specifically found the court should make reasonable efforts to preserve the homestead interest if the property is divisible. And the court found that because of the parties' relationships, that the fact that there would be easements that were required rendered this a situation where the property couldn't be divided. However, that finding overlooked the fact that, again, every witness testified that the easements were not necessary, that to the extent that you couldn't put up a fence to deal with the pond view, that the loss of a pond view had negligible value on the property. Mr. Carter specifically testified that the value of the pond, if you lost the view, was only a $2,000 to $5,000 deduction to the value as a whole. Further, McNamara versus Mossman, a case that we cited in our brief, says specifically that the loss of an attribute alone does not generate prejudice. Therefore, the substantial competent evidence that the court relied on, strike that. There was no substantial competent evidence to rely on, just as in the Thompson versus Mitchell case, in the first DCA case. There, the court decided that the property should be sold based on this one homeowner's unsupported testimony that if it was divided, you couldn't hardly get to her property. The first district said that was in error, and the court's finding that the property should be sold and not divided should not be accepted. I'd like to reserve the remainder of my time for a rebuttal, please.
You may.
May it please the court?
Yes.
Aaron Sprague for the appellees. The first thing I want to do is address some of the issues that were raised by my colleague on the other side.
Yes. Why shouldn't we grant the motion to strike your supplemental authority? Because these are cases that certainly predated your briefing in this case. I mean, it seems, I wholly agree with your opposing counsel that this is an abuse of the notice of supplemental authority rule of simply, well, you can shake your head no. I do think it, and I think it's a sanctionable event, but I don't have that authority presently under the rule. But I mean, you don't get surrebuttal. That's in essence what this is. I know you don't explain, you don't argue in your notice, so I'll give you that. But I mean, to cite cases that predate this case.
Your Honor, I have no intention of arguing with the court on that. The cases cited go to legal issues that were raised.
I know what the cases are cited for. I get that, but I mean, you know, you could have argued that in your answer brief. I mean, obviously they were unhappy about the wholesale adoption of the proposed judgment from your trial counsel.
We did argue them in our initial brief.
Well, you should cite those cases because they existed. That's my point.
And my only answer to that, Your Honor, was when we drafted the initial brief, we were in front of the first DCA and therefore cited first DCA case law. When we were transferred to the fifth DCA, we thought out of abundance of caution it would be wise.
You don't cite fifth DCA cases to the first DCA? What, did they hurt their feelings or something like that, or what?
No.
I'll make R&J about that when I see them.
Mr. Sprague, there is a first DCA case, Eaton versus Eaton. You still cite that first DCA case. You cite two fifth DCA cases, but all of them, we've got a 2020 case, 2019 case, and a 2022 case.
Correct, Your Honor. And again, I don't want to argue the point with the court. I believe that the legal principles are well established, even if the court were to not consider those cases. If the court is inclined not to consider them, I don't have any intention of arguing it with the court on that point. All right. So the first thing I want to do is address squarely some of the things that were raised in my colleague's oral presentation. First, the comment that fencing would fix the camera issue, that was raised in their initial brief. That factual statement is misleading. If you look at the quote from Mr. Rentmore in the transcript at pages 274 and 75, he doesn't say what they claim he says, and I'll let the court look at that at your convenience. Also, Your Honor, Judge Wallace, you were completely correct. There was an incident where the RV was moved from its position on the side of the property to the circular drive, which directed cameras at the Rentmore's property, and that is also in our answer brief. The next thing that I want to address is the issue from page 611 of the record where counsel claims that the court abrogated its obligation to construct an order of its own and was just going to delegate to the Rentmoors Council. That is also misleading. What was going on, and I encourage you to read that part of the record in context, because Houston's counsel came into that hearing. The court asked if they still wanted to do competing orders, and the portion of the record that they're citing to is the court at Ms. Houston's instigation, still indicating that they wanted to submit competing orders. And so at Ms. Houston's instigation, the court gave them that ability to do so.
How much time did they have to object to your side's proposed final judgment before it was entered?
I believe it was 4 months, Your Honor. I could be wrong, but it was a matter of months, not days.
I don't see it in the record, but maybe I missed it in the record. Were there any objections raised to the proposed?
There was not. And Your Honor is right. There was also not a motion for rehearing, which is something that we will address here as I turn my attention to preservation. Because there are several preservation issues with the position of the appellant. First of all, the legal standard that they argue should be used to analyze this case. In the trial court, they argued 64-209.
How did that come about anyway? You look at the statute, A, it became effective after the case started, and B, it talks about what commissioners should consider, not a trial judge. But and I know you were not the trial counsel, but it sounds like everybody traveled under the 64.209 right of access. I'll use that for partition purposes.
Your Honor is exactly correct. Why we are here arguing 64-209, both sides, is because that's what everybody argued in the trial court.
Okay.
And so, however, in their initial brief, they abandoned their arguments under 64-209. It's never cited, never mentioned once. Certainly, they never argued that the 64-209 was misapplied. They urged the court to adopt the Amger approach in stating that the value of the property is the only thing that matters. And then, when we point out that that was contrary to Florida law, they shift ground again in their reply brief and argue for the first time that the court misapplied section 64-209. And that is an argument raised for the first time in reply and therefore not preserved. And that's going to infect a lot of things that we're going to see in their arguments going forward. The next thing
What about their argument that, okay, let's assume this court says, all right, we affirm that it's indivisible, but we don't agree that it should be sold in the manner that it's been directed to be sold by the judge. You have to have a different process under the statute. And oh, by the way, we didn't agree to anything like that whatsoever that the judge ruled in.
Your Honor, let me address that squarely, because that also has not been preserved. Nothing about the method of sale was preserved. In fact, they agreed to it in the trial court, and we cite that in our briefing, and I'm going to read to you the quote. We are very concerned about some kind of bidding war or something going on between the parties. We obviously think that the correct result here is to divide the property, but if Your Honor is not going to do that, then it should be set up in the manner that you're discussing in terms of a receiver.
So you believe that the trial counsel at that point for your opponent should have said, Judge, I don't think that the property is indivisible. It should be divided by commissioners, but if that's not the way you're going here, then we want to make sure that it's then sold at a public sale or consistent with the statute.
Correct. That's exactly what they should have said.
At that point, the judge, it's squarely hitting him in the face saying, okay, if that's the route you're going, chum, follow the statute. That's how it should be sold. But when you tell the judge otherwise, the judge is free to rely upon your representations.
Right, because it's an invited error, Your Honor. And then the next thing, plus the case law is clear that you can do a non-public sale if the parties consent, and that's consent. Now let's take the position of the appellant, that this is not consent and that this error appears for the first time on the face of the final order. Well then, Your Honor is correct that they had an obligation to raise that by motion of rehearing. For rehearing, because errors appearing for the first time on the face of a final order must be raised in rehearing or they're waived.
Do you think the motion for rehearing rule that's been amended by the Supreme Court talks about you need to raise those things if there's insufficient findings, or just, give you a second chance to, because there's that the angst between the rule of, don't re-raise something that you already raised just to complain about that you lost, as opposed to, if there's insufficient findings, bring it to the judge's attention so she or he can correct that before it goes up on appeal.
Right. So here, what the position that they are taking is, this is an error that didn't occur until the final order. So it's not something that they argued, that lost on, and then were going to re-argue. It would have been something that appeared for the first time in the final order that they needed to raise on rehearing in order to be waived, in order to be preserved, which they did not do. So there's just...
And they could have done, because they did it here.
Yeah, exactly.
And that's something that, something that Judge Eisnagel wrote in his concurring opinion, and to my
Precisely, Judge
one
Lambert.
case that we're not going to talk about.
Right. So I want to just touch briefly, and I don't want to belabor this very much longer, but I want to just raise a couple of more preservation issues, whether the court erred in considering the relationship of the parties. Again, in the trial court, they take one position. In the initial brief, they say that it's an error as a matter of law, relying on a bunch of foreign cases from other jurisdictions. And then in the trial, in their reply brief, they say, well, it was right for them to consider that, but it was given too much weight under 64209, an argument.
To be quite frank, I think that's kind of their common theme throughout the entire case. The trial judge put too much weight on the relationship between the parties and basically discounted or didn't give any weight or very little weight to the value of the property as far as the sale or what form of sale to take place.
Very good, Your Honor.
That's a fair assessment, correct?
I think that one of the things they argue substantively throughout is the weight that the court gave to the relationship between the parties. Now, let me kind of address that substantively because Your Honor raised it, and I'll endeavor to show why what the court did was proper under 64209. 64209 gives 7 factors to consider, one of which is a catch-all, which we've already discussed. The other, under 1A, is the practicability of dividing the property in kind, whether it's practical to do that. 64209-2 says that any one factor can't be determinative without considering all the factors. Now, what that statute does not say is that all factors must be given equal weight. It doesn't even say that one factor can't be determinative. It just says all factors must be considered. So if you look at the court's order, it follows that to a letter.
Well, the catch-all subsection, though, says any other relevant factor, and I think gleaning from your opponent's argument is whether these people like each other or don't like each other is not relevant to this, so it shouldn't even come in the mix. What do you say to that?
It is relevant for the following reason. All of the testimony from Houston, their expert Hall, was that the property, in order to be divided in kind, it needed to be done with a number of easements imposed. And again, to quote, the parties stipulated to a portion of Brian Hall's testimony as follows. Brian Hall rendered no opinion of the subject property as if divided and not encumbered by any easement. In other words, his testimony was that if this property is divided in kind, you need to impose easements, one of which was a negative easement for Pondview, the other which, despite the separate access point, was an easement for joint use of the main drive. And he had no opinions, in this case, other than in-kind division would result in easements. So what does Schroeder teach us? Schroeder actually supports us. Schroeder teaches that if you are going to divide a property in kind, easements are not practical if the parties have an acrimonious relationship, because in all fairness, what you then ask the courts to do is be a supervisor ad infinitum of that property as these people who can't agree on anything fight over their joint rights under these easements. So it is relevant because it goes to the issue of whether the property can be practically divided. And so, going back to 64209-2, there is nothing in the statute, in that language, that says that any fact or factor, or set of fact or factors, cannot be given great weight, which is what the court did and what it was at liberty to do under the statute. The court says it's taking into account all the factors, notes that the statute does not require it to weigh all factors equally, chooses 5 factors to highlight in the order, and says that it gives great weight to the relationship of the parties, which it was entitled to do. What we have heard, and I think what was conceded by my colleague, is that there was competent and substantial evidence to support ongoing relationship issues between the parties. And because there were, the easement plan testified to by Mr. Hall is not practical under Schroeder, and therefore the property cannot be divided in kind without prejudice.
So you basically see this case as the trial judge was given competing expert testimony, one as to its divisibility and one as to its indivisibility of the subject property. The judge, whatever comments that he might have made about discounting your side's expert, at the end of the day it was a weighing of the expert testimony, and the judge found in favor of your side, for lack of a better term, so at least thought that the expert witness testimony was more credible. And under those scenarios, we don't reweigh the credibility determinations made by the judge, and therefore the expert's testimony on your side is competent, substantial evidence to support the ruling, and you ought to affirm it and have a nice day.
Substantially that, Your Honor.
Free of softball, you could say, yeah, it's good.
Yes, substantially that. I think there's some nuance there.
That's what your argument basically is. I mean,
Right.
I know you're addressing the various arguments cogently raised by your opposing counsel, but at the end of the day, that's kind of
Right, and it
where
goes
you're
down
landing
to
here.
what the competent and substantial evidence standard is. This court, under that statute, or under that standard, under Clegg and Griffin, it doesn't ask if there was evidence to support a different finding. For instance, it doesn't get into, could the property be divided without easements?
I mean, in essence, you're saying if the judge
Right.
said, we like Mr. Hall's testimony, and he agreed with Mr. Hall's testimony, order partition, you basically would have to say with a straight face, well, you know, that's, judge weighed the competent evidence, he thought that was more competent, and I'm dead in the water here.
Correct. And
Probably politer than that, but.
in this case, Hall offers testimony that easements would be necessary to divide the property. That's competent and substantial evidence, and this court, it's not within the analysis of the appellate court to then reweigh or look at the evidence to see if there was something else the trial court could have done.
You want to tell Judge Sow that, you know, don't be a trial judge anymore than about weighing evidence. You can't reweigh evidence up here.
Your Honor, I want to touch briefly on the homestead exemption issue. Again, here we have a preservation issue in that
I think your opponent, I mean, your counsel's conceded that. I mean, if it's divisible, then that applies. If it's indivisible and we support that, then you don't get the homestead exemption anyway.
I think where the disconnect comes in is this, and I'm running short on time, so I just want to make this point. There was an
He'll give you more time. He's good.
Maybe.
There was an implication that the court gave this no consideration. And the court did, and I would encourage you to look on page 600 of the record where the court actually found compelling Ms. Houston's testimony about the fact that she made this not only her residence, but her home. And notwithstanding taking that into consideration in Houston's favor, ordered a judicial sale of the property. So even if this argument has been preserved, which we contend it hasn't, the court took that into consideration when dividing the property. Your Honor, finally, let me turn briefly to the value of the parcels if divided in kind, because there was an implication that the court did not consider that at all. The court did. That is on page 589 or 598 and 599 of the record. It had a competent and substantial basis to conclude that it'd be worth less because of the easements imposed and because of the nature of the property as rural acreage. That's also in the record, and you can look at our briefing to find the citations there. Finally, there's one thing I would like to point out, and it has to do with the relationship of the parties and the argument that this was the sole thing that the judge took into consideration. That argument is made in the reply, and the court and the appellant has given 12 citations where she says it shows that the court was only considering this. If you look at those 12 citations, and I would encourage you to do so, what you're going to find is that one of them, it's not even the court talking. 5 of those, the court doesn't mention the relationship at all. It just indicates its position that it's going to be difficult to divide the property in kind. Of the remaining 6, nowhere does the court say this is the only thing I'm thinking about. Clearly the court was concerned about the relationship of the parties, and it was right to be and had the ability to be under the statute. But if their court had ever said, this is the only thing I'm considering, I'm sure we would have seen that in bold in a block quote in briefing somewhere. And we never saw it because it never occurred. Just because the court says that it's worried about one thing does not mean it's not worried about other things. And that is reflected in the order, and I see that I am out of time.
Thank you, counsel. And counsel, you have about 3.5 minutes.
May it please the court, I'd first like to address Florida Statute 64.209 and why it was discussed. At common law, the courts were allowed to consider any factor when determining partition to determine whether or not there would be prejudice. 64.209, which was created after this case and was not binding on the court, as we pointed out to the court in our initial brief, we found was instructive because it was a codification of factors that existed at common law. 64.209 was created specifically because despite the fact that there is a presumption against the sale under the common law, courts are routinely selling parties' properties. Therefore, this Uniform Heirs Partition Act was created and has been adopted across many states to combat the very problem that we have that happened in this case. This is Mrs. Houston's home. She is the person who found the property. She has done everything she could to maintain this property, to improve this property. We are talking about a property that has 2 houses sitting on 4 acres, that has different water systems, that has different electricity, that has different access availabilities. The property can be divided, and under Tullis v. Tullis, it should be, to preserve her sacred right to her homestead. To look at this and say the fact that the parties can't get along is a reason to force her from her home, that's why this statute was created, because courts would look only at the value of the property and not the other factors to realize what are the personal attachments that people have to their property. So here, the court erred in elevating the factor of the parties' relationships. In Schroeder, as we mentioned before, the brother and sister did not get along. There were 2 separate access points, so the court said, we're going to divide the property that way, give you guys your separate access. They specifically said, we don't need to reach whether or not an easement by necessity would be required here. That's not saying that easements by necessity can't be ordered. They're saying under the circumstances of this case, we don't even need to go there because we can separate the interpersonal problems with these different accesses. That's exactly what we have here.
Let me ask you this, counsel. Let's assume this trial judge decided not to make gratuitous comments that, obviously throws issues into the fray here, and just had just sat and listened as a trial judge and listened to all the evidence, let everybody present their case and present their experts, and said, okay, I'll decide, and he writes a judgment that's similar to what you're unhappy about today. The question I posed earlier to your opposing counsel was, okay, if the judge is simply listening to competing testimony primarily from the experts and sides with one of which why wouldn't that be kind of difficult for your position on appeal here, because we obviously don't reweigh why the trial judge thought that the testimony of that expert was more compelling. Just like I threw out, if the judge said, I like what Mr. Hall said, you'd walk in with an easy win today.
Because Mr. Hall didn't have any evidence to back up his opinion that the
Mr.
resulting...
Carter, you like Mr. Hall, right?
Thank you, Your Honor.
You make it
Yes.
a lot harder for you if you told us Mr. Hall didn't, so.
Mr. Carter did not have any evidence to back up his opinion about the resulting parcel value. He simply stated without any data that he thought it might be less. There was no expert opinion rendered by Mr. Carter as to the value of the resulting parcel. Specifically as well, Mr. Hall did not say an easement was necessary. As we cited in our brief, he testified specifically, would your resulting conclusion about the value of each parcel be different if there was a separate access to the property versus a shared driveway? Answer, no.
Counsel, I'll give you a moment to wrap up, but you're at the end of your time.
Thank you, Your Honors. As it's demonstrated in our briefing and through the cases, there was no substantial competent evidence to order that this property should be sold. The presumption that the property must be divided so that the property owner's property rights are protected should be applied here. The court should overturn this ruling and tell the judge to appoint special commissioners to divide the property. Thank you, Your Honors.
Can I ask you just one thing?
Yes, sir.
Is this your first time appearing in front of our court?
I appeared through Zoom once. This is my first time I get to appear in person.
Okay, you did a nice job. Thank you, counsel.
Thank you.
Thank you, counsel, for your arguments. And now, if counsel will indulge the students that we have here today, I think they're armed maybe with a couple of questions too. But to start out, we can start with Ms. DeCunto. Could you just give maybe the students the benefit of your background, your education, and how your career path led you to be here today in front of our court, please?
Sure. So I'm from Jacksonville, Florida. I now live there on purpose. I went to Wake Forest for my undergraduate, and then I went out to Los Angeles to the University of Southern California for my law school. Love law school, never wanted to stay in California. I wanted to be a public defender for my career. I wanted to defend people that were possibly receiving the death penalty. So I became a public defender down in Miami. My husband's from Los Angeles. It was easier to get him to Miami than to Jacksonville. Luckily, he did not care for Miami, nor did I, so I got him to move to the public defender's office in Jacksonville. Love that office. As you're an adult, things change in your life. I had my first child, and things changed for me. And I wanted to prioritize raising that son and then my second son. And I had an opportunity to join a private law firm that would give me the flexibility to stay at home and work for them and also have my son. Luckily for me, I love business cases. This case is a little bit different. It's a little bit, well, we're not talking about this case. I love business cases. And so the pressure was off when you were no longer worried about is someone going to go to prison. That's hard. When you're arguing about money, there are lots of times business resolutions that people can reach. And so for me, I also found that the business law, you get to hear and work with lots of really complicated areas of the law. And when you're a public defender, a lot of times you get that when you're dealing with constitutional issues, things like that. But on a day-to-day basis, a lot of times it's really just fact-intensive and trying to figure out, you're not necessarily dealing with really diverse areas of the law.
Let me ask you, counsel, how did you get in the world of appellate law, like you are here today?
So I love briefing, and I like the appellate law. Once the factual issues are distilled, so that you're not supposed to be arguing about what the facts are anymore, you're just really arguing about complicated legal issues. And I think that that's fun. So it's nice to kind of distill these complicated legal issues into a place and get to present them to.
Were you the trial lawyer down in this case?
I was a trial lawyer in this case.
So there's a difference between preparing for a trial and preparing for us here on appeal?
Yes, and I think it's hard when you're a trial lawyer to switch that, because it's very easy to just keep arguing what you argued before, and now when you're here, you're not getting to make the same argument that you made to the lower court. Now you're having to say to these to this panel why the lower court was wrong. So to the extent you're just trying to re-argue, you're not going to get very far. So it's very different, and I think sometimes, a lot of times, lawyers are only appellate lawyers. They're not necessarily the trial court lawyers, and sometimes that's an easier thing because then you're always in that lane. I think it's hard to switch from being the trial advocate to the appellate advocate.
And counsel, how many hours can you estimate you prepared to get ready for this oral argument, which lasted, what? They saw it here today. The whole thing lasted 40 minutes, so.
So first, preparing for this starts with the initial brief, right? And the briefing takes a really long time, multiple hours, a lot, 20, 40, I'm not even sure. And then we also have the chance to do a reply brief since I'm the appellate, so that's also a long time. And then it's a question for me of distilling everything that we've said in those briefs into now a 20-minute presentation. And knowing that you're going to be kind of the victims of the court's questions. So you can create whatever you want to say, but that doesn't mean you're going to get to say that. So you have to be ready to be nimble, to not say what you just had on the paper, and to answer what the court's interested in. Because
Many people have thought they've been victimized by Judge Wallace's questions.
For their context, your initial brief's 47 to 48 pages. Not a small undertaking.
correct.
The answer brief's also substantial in its length as well.
And many people have been on receiving ends of Judge Lambert's compound questions, too.
My overwhelming humor.
I believe mean that there are things that you want to say, but what is important is to listen to what the courts want to know, because that's who's making the decision. So it's more important to answer what they want to know than to tell them something that they're not interested in.
What do you do to try and anticipate what we're going to ask, which is a very hard thing for anybody to have to do?
I have, for my argument, I create every time, I have done oral arguments in other places, and I learned this in law school from moot court, and so I outline every single thing that I think I could ever say, highlighting cases and things like that, so that when the court asks me a question, I know where is that topic in my outline, and how am I going to go to it, and just use this as a cheat sheet. And I find this really helpful because then I'm not flipping through a bunch of papers, and it distills your argument, because there's only so much you can keep. This is actually pretty good. I don't have these 2 pages filled, So I try to just distill it down as much as I can to just have it be a cheat sheet, to then be ready to specifically cite to the record or anything I think that they could ask about.
Thank you, Mr. Kunto. And Mr. Humphrey.
Sprague.
Mr. Sprague, I'm sorry, Mr. Sprague. Yes.
Same question?
Yes, yep.
So I grew up in Seattle, Washington, which is geographically about as far as you can get away from here. I went to Brigham Young University, and then I went to the University of Michigan for law school. And then we applied for jobs everywhere that we had family, and we ended up in Jacksonville. And so I was with a firm of trial lawyers for about 6 years, and then I suffered a temporary bit of insanity. Took a job with the Oregon Department of Justice, moved back to the Pacific Northwest for 3 years, and then found that it was difficult to be in public service and still raise a family. And then, by the oddest coincidence, was able to get back on with that same firm of trial lawyers, move into the same house, put my kids back in the same school. So it was like I was abducted by aliens for 3 years, and then dropped back into my old life.
Back into the sunshine, right?
And so how I came to be doing appellate work as opposed to trial work is like this. My bent, my interest in kind of what I'm best at has always been briefing and arguing to the court. So there was a system that just kind of evolved organically in this firm of trial lawyers that I'm with, that I do all the talking to the judge. So if there's motions in the trial court, if there's arguments to be made in the trial court, evidentiary issues that come up during trial, I handle all of that. If somebody asks for a case to be dismissed, I handle that. And so over time, I became what we call the judge whisperer. And then there is a very, very good firm of appellate lawyers in Jacksonville who we have worked with extensively. And I came to be associated with them, and I wear then two hats. An appellate lawyer hat with this firm of appellate lawyers, and I still do trial work with this firm of trial lawyers. Because everyone just kind of realized that what I do is much more similar to appellate work and trial work, and so that's how I became to be in the appellate work. I've done several oral arguments, briefed a number of cases, and I really enjoy it.
And trial work is stuff like maybe students have seen on television where there's a jury. There's no jury in this case, but there's a jury and the lawyers call witnesses and the witnesses are sworn in and they testify about things, and then either a jury or a judge makes a decision based upon what's been testified about, whereas obviously we don't take evidence here. We just talk about what happened, and you're trying to tell us that good job below, no error, nothing to do but just affirm it and go on and let the judge's ruling stay where it is, whereas your opponent thinks that wasn't the best choice based on the facts of the case.
Right, and that's where we are in this case. There's been cases where I've been on the other side, where I've been arguing for reversal. Trials are a lot more boring than what you see on TV, and there's times when a jury will get actually sent out of the room, and the court has to take up whether a certain piece of evidence is admissible, whether we get to show it to the jury, and I will be quietly lurking in the back, and I will come forward to the argument in the trial court, because that's kind of my role when I'm wearing my trial hat. So here's what I did to prepare for today. I prepare my outline. I look at the points that I think are things that I have to address affirmatively, and then I try to prepare for questions. And then about a week ago, my colleagues and I had a mock oral argument where they took on the role of court, and I took on the role of the person arguing, and they peppered me with questions so that I could be prepared for the panel's questions. And in terms of time, getting ready is a long effort. There's briefs to be written, that takes a long time. And then in preparing for today, in addition to the oral argument, several full days.
Because this is your one shot. In other words, you don't get to say, boy, when you're riding back up to Jacksonville, say, I forgot to talk about that. Maybe I can call them up and we can come back and have another chat a little bit about some more stuff that you thought about when you're on I-95.
Judge Lambert is exactly correct. It is your one shot, but I will tell you this, and I'm sure Judge Lambert will tell you the same. That's not going to keep me from getting on I-95 back in Jacksonville and saying, you know what, I really should have done, because that's just the nature of it.
Mr. Sprague, how many times have you come to a court, done an oral argument, and with all the preparation that you've had, and then when you leave the oral argument, you think about the number of questions that either was asked of you in practice versus in the oral argument, and the two don't match up?
So you never can fully anticipate what a court is going to ask you. You can come pretty close, and if you prepare well, I think that you're going to be ready, at least in terms of topics that are going to be addressed. I think you can be ready for probably 80–90% of what the court's going to ask you. But sometimes the court's just going to ask you something that you didn't cover in your mock oral argument, or that wasn't in your notes, and then you just got to trust your own knowledge of the case, your own persuasive ability, and your knowledge of kind of what is persuasive and what is not.
Well, let me ask you this. Do you prefer the panels ask questions or not ask questions, or does that depend upon which side of whether you're the appellant or appellee?
Oh, that's a really good question, Judge Lambert. I'm not sure I have a preference. I've had very active panels. I've had panels where I have not been asked a single question. And I would add this, attorneys, when you leave here, you always try to read the tea leaves, and you're like, oh, well, they ask this question, they ask that question, does that indicate what they're thinking here or there? And, can I glean from what the trial, or what the appellate court asked me, whether I'm going to win or lose? And you're always wrong. I've had cases where, for instance, the court did not ask me a single thing, and within 10 days I got an order saying that I lost. I've had a time where the court didn't ask me a single thing, and within 10 days I got an order saying I won. And it's just kind of, you prepare, you address what the court addresses, and you trust that a correct decision was made.
Have you ever left an appellate argument and thought to yourself, wow, those 20 minutes really moved slowly?
You can all see the countdown clock. I will tell you, the time evaporates. You start talking about preparing. I'll go through and I'll make sure that I can make all of my affirmative points comfortably within the time allowing for questions. And then when you get up there and you're kind of working through your outline, you're answering the judge's question, you look at the clock and all of a sudden you realize you've got 6 minutes left. And yeah.
So I think the answer to that question is no.
No. Time never drags. Time never drags, especially when you're in front of a panel that's pretty active.
And it's all from the perspective, because I know Judge Wallace and I, we've had colleagues in the past who would lean over, is this almost over? Is this almost, are we almost done yet? Or they'd be clicking their pen or doing so, we're all former trial judges too, so sometimes, as a trial judge, you sit there and you're listening to the witness and says, is this ever going to end? And then, but when you're in the fray, it just kind of goes by. You're thinking, well, I'm here for 2 or 3 or 4 days of trial, and it kind of goes by faster than you think. But it's all perspective.
Thank you, counsel. So, does anybody from the gallery have, from the students, a question? How about one question for each lawyer? Yes.
Grayson's going to go first.
Grayson.
You guys stand up. You guys tell them who you are.
I'm Grayson, and I have a question for you. Would you ever want to be a judge one day?
Definitely.
How come?
Because I just know that some lawyers become judges at some point, and I was thinking, maybe some people stay lawyers for the rest of their career and don't ever become a judge.
So I agree with you, and different lawyers want to be judges, and some lawyers do, and some lawyers don't. I think that there are judges or lawyers that really love the performative aspect of trial court and being in the trial and the kind of adrenaline you get with that, and those people that I know, that's their role and that's where they want to stay. Because I explained to you that I like really complicated legal wonky issues, I think that as a judge you get to hear such a wide variety of issues, and you get to decide these wide variety of issues and have a real impact on people's lives, that I think it would be a really interesting.
All right. Somebody have a question for Mr. Sprague?
Don't be shy.
My name is Julia, and I had a question for you. Do you have set legal strategies that you use depending on the type of case?
Or maybe depending on the type of panel that you see, because you're more appeal court, right?
That is a question I'm not sure can be given a universal answer. It depends on the issue, and it depends on what side you're on, and it depends on the panel. Arguing on behalf of the appellee, where you know that you have some, where the legal standard favors you, you're going to make different arguments because of the seat that you're sitting. When you're the appellant, you're going to also, I think, do things a little bit differently because of where you are. to say that is universal. One thing that I would say that is universal has not to do so much with arguing with the court, in oral argument. It has to do with briefing. And that is, you need to say things. It's more persuasive to use fewer words. And when you write, and you're trying to argue a point, if you cloud your argument with a bunch of unnecessary verbiage, the eyes of the court just kind of glaze over, and they go into a stupor, and you're not convincing
Stupor.
Nice. He's actually, I know it sounds funny, but he's very accurate about what he says, because we read a lot. So if you give us a 100-page brief about something that you could have said in 22 pages, it focuses us to what we're going to be talking about, and it's appreciated.
Let me just build on that a little bit. It's hard to express to people who kind of don't live in our world, but there are some things that are just so, you just assume are universally known. And you know that you have experienced lawyers, then judges, then appellate judges, and I personally would not waste words briefing, like the standard for summary judgment for issue, because the court knows that.
And for example, we talk about the panel. I know it's different because you guys just came from Jacksonville and we've just been realigned, but us on the panel, we're all trial judges first. So we've all been through many trials. So we understand how trials operate. So explaining to us, well, this is what happens in a trial. You only have a limited number of words that you can use in a brief. It used to be pages, but the Florida Supreme Court decided to go word counting instead of page counting for reasons that I guess they can best explain. So you have to choose your words carefully and concisely to help get your point across as best you can.
No more than 13,000.
Right.
Yes.
And you need to be focused in the issues that you choose to argue.
And it's funny to read the last page of their briefs. They'll say it has to be a certain font, because that's an important thing too up in Tallahassee. And it has to be a certain font, and it'll say, and oh, by the way, it's 12,214 words here. And one of these days I'm actually going to count these things and say, it was 12,219, pal. You gave me 5 extra words there. I got you.
You'd be surprised how as students, given an assignment, it has to be at least so many pages, right? You're struggling to get over the page limit. We're given a certain amount of words to stay under, and lawyers universally struggle to stay under that. And you have to be focused and concise and be persuasive.
Thank you, counsel. We'll call the next case.
Thank you very much.
Yes.
So we're going to have coffee after the second argument. You can stay or not. We appreciate that. We well argued on both sides. Thank you very much. You gave a good presentation for our students to watch.
And the next case that we have, and the lawyers can position themselves for that, is Miller versus Department of Highway Safety and Motor Vehicles.
You got a stun belt on him over there? If he says anything, you're going to shock him? That was your case, man.
Okay. Ms. Cohen. All right. I will assume 5 minutes of rebuttal unless you tell me otherwise.
That is correct.
Okay. You may begin when you're ready.
Thank you. May it please the court?
Yes.
And I do have a, procedural issue. My heel broke on my shoe on my way over here, so if I walk a little funny, that's just because I'm trying not to fall and literally break a leg.
Judge Wallace is barefoot up here anyway.
I debated, but I'm so short that you couldn't see me, so that wouldn't work. We're here today because of an issue of statutory interpretation of Section 322.28, which is the statute which addresses these mandatory suspensions of driver's licenses when someone is convicted under 316.193, the DUI statute. And so the question is one purely of statutory construction. In order to look at that, we have to look, obviously, at basic rules of statutory construction. And the first thing that the court has to look at, as we all know, is the plain meaning of the words that are used in the statute.
They call that supremacy of the text up in Tallahassee, don't they?
Yes, sir. Yes, sir, they do.
Big fond of that term, aren't they?
And in doing so, though, it's not you can't look at just a line in a statute. You can't look at even just letter C in a statute without considering everything that is contained in the statute. We also cannot look at one section and render it unnecessary or meaningless.
The reason that's important here is the statute actually says the court shall permanently revoke the driver's license or driving privilege of a person who has convicted for 4 times for violation of basically the DUI statute.
Yes, sir.
And your client had 2 separate incidents.
Yes,
where
sir.
he had 2 DUI convictions in the first incident and 3 in the second. So that totals 5. So if we don't get past that first sentence, that's problematic for you, isn't it?
It is, except if you look at the exact language of that first sentence and read it in context with the language of the rest of the statute. It doesn't say has 4 convictions. It says has been convicted 4 times. And in each other section of the statute, when they talk about the number of convictions, they talk about prior convictions. They repeatedly talk about subsequent convictions. And most significantly was the amendment where they specifically stated that if you have 2 convictions on one day arising out of separate dates of offense, the legislature felt it necessary to say those count as separate convictions.
Ms. Cohen, so effectively what you're asking us to do is to interpret the statute to mean your client needed to be prosecuted and convicted on 4 separate occasions. Is that what you're saying?
Yes, sir. And I'm not asking the
The
court...
statute doesn't say anything about prosecution or the number of prosecutions. Is that correct?
It does not, but it also does not say anything about the number of convictions. It talks about being convicted 4 times. And I think the language is important, particularly when you look at the rest of the statute. It talks in terms of if there's a bond forfeiture on a first conviction, this is what happened. For any subsequent convictions, this is what happens.
So if there is a conviction, like in this fact scenario, there were 2 separate cases, 2 separate prosecutions, and involved multiple victims in those cases. So basically what you're saying is, and the effect of that is to disregard the individual convictions against individual victims for the individual wrongs. Is that correct?
That is yes and no. Because in doing so, you're lumping together the criminal aspect of the proceedings, which imposes a sentence and a penalty. The license suspension is not a penalty. It's an administrative action taken to promote public safety, but also as set out by the legislature in its specific intent under this section to prevent repeated violations of the traffic laws. So if you look at the language that the legislature has used...
It's a penalty, but the purpose of the penalty is to provide added protection to the public for someone who clearly has, at least on paper, shown an issue with abiding by the law, specifically in this case, driving under the influence, correct?
Well, while you and I would probably agree that it is a penalty, it's a severe penalty to lose your license, from a legal standpoint, the Supreme Court of Florida has repeatedly stated, and the department even noted that in their brief, has repeatedly stated that it is not deemed a penalty, that it is deemed an administrative portion. In fact, if you look in 316.193, which is the DUI statute, it sets out all the penalties, the fines, the probation, the ignition interlock device, all the various things. It does not mention license suspensions.
So in this scenario, just so I'm following along, so if a person, let's take it outside of your client for a second. So defendant's, soon-to-be defendant's driving, he or she is under the influence to the extent that her normal faculties are impaired, gets involved in a car accident or causes a car accident that kills 4 people in the other car. They can, 4 DUI manslaughters. I mean, there's no double jeopardy issue. I think it's clear. And so, if I'm following along, they could be convicted 4 times for that single incident of a DUI manslaughter, and they're gonna, and actually, you know, it may be a moot point because they're going to score life absent a downward departure because they're going to have 480 points on their sentence score sheet. But assuming that they're allowed not to, they're not put in prison for the rest of their lives, under your argument, I guess, correct me if I'm wrong, that would only count as 1 conviction under the license suspension statute.
It would, because if you also look at it from the other end, because the statute has to be applied equally across the board, as I think one of the examples I used in my briefs is if you hit the mailman, it's one conviction, 1 suspension. If you knock down 3 mailboxes or 4 mailboxes and you don't hit anybody, you can charge each victim who's damaged separately. That would now be a permanent
Or
revocation.
if I consecutively hit cars, 1 person in each car on my criminal day of driving, and I was charged with 4 counts of DUI manslaughter, that'll occur on the same day with 4 different victims, but in 4 different cars, that would be a suspension for life, right? Permanent suspension.
Well, now you're getting into, they've changed the statute a little, so for other reasons it would be, but it becomes the prosecution, the act of driving. If you hit somebody in Daytona and then you go into Jacksonville and it's 3 hours later, it's a separate offense. The bottom line is, if you look at the plain language of the statute, and we can talk about all kinds of not doomsday, but very bad scenarios. And I'm not saying that my client is somebody who is the best example. You know, you don't pick your clients for your cases or for the
And
law.
it's not really too far off because your
But-
client's
right,
first
because
conviction was a 2
Sometimes
DUI,
bad facts make bad law.
2 manslaughters in 1 day.
Yes, sir, and sometimes bad facts make bad law, but the bottom line is that whatever interpretation of this statute, whatever the legislature said, and the legislature knows how to say what they want. They could have said multiple convictions with multiple victims count as separate convictions, but they didn't. They specifically stated, when they amended the statute, that separate convictions for offenses that occur for different offense dates.
Well, they could also have said separate prosecutions, back to my question, and they didn't put that
They
in the
didn't
statute.
put that either. Everything in this statute is talks about sequential. Every single aspect of this statute talks about sequential actions of the driver. And this is just the license suspension. If the court said somebody's going to go to prison on a serious offense, they're going to go to jail, they're going to be off the streets, and their suspensions don't even start until they get released from prison. So it's going to be a long time, but that none of that detracts from the fact that our baseline is, what did the legislature say? And one of the cases I cited was that James decision where he was a sex offender. And he said, oh, I don't have to register, I can do whatever I want because I didn't pay my fine. So I haven't completed that part of my sentence, so I don't have to register. I can go wherever I want. And the court said, well, that's true, because the legislature could say that you have to start registering even if you haven't completed that, or write it in a different way, and I think they've since amended the statute. So we don't always get the outcome we necessarily think we should, but the bottom line is, what did the legislature say? And that's where we have to go back to each time, and that's why if you look at all of the language under 322.28, in every section, it is sequential. And if you look even under the legislative intent, it talks about the concerns about repeat behaviors, and that's how that particular section of the law is to be interpreted.
Well,
Again,
part of our job in the world of DCAs is to read the proverbial tea leaves from the Florida Supreme Court. And based upon who's on the court presently, you're basically saying to us that the court would read that statute, the court shall permanently revoke the driver's license or driving privilege of a person who has been convicted 4 times for violation of 316.193 or former 316.1931, or a combination of such sections, that the Supreme Court would say that, well, you need to go past that because clearly your client has 4 or 5 convictions. And
I'm not really sure, because you're not really going past that, because the question is, has 4 convictions.
We have-
I mean, has been convicted 4 times mean versus
Well, he has
has
been
4
convicted.
convictions.
He has been convicted 5 times. He has 5.
He has 5
If
convictions.
you asked him under oath, how many times have you been convicted of a DUI, he has judgments with multiple convictions, 2 different judgments, but with multiple convictions. They're not asking how many times did you have a judgment, it's how many times were you convicted of this crime.
And I would just bring the court back, I mean, I think I have to bring this court back to the basic rules of statutory construction, which is that you have to read the statute altogether, that the legislature has amended the statute throughout the years to address issues that it believes are issues. I mean, if you look back at the first time this gentleman was in court, the department only gave him a 3-year suspension, whether that's good or bad, but they did not count it as his second, even though there were 2. So even the department didn't interpret it that way.
Let me
And
ask
it
you
wasn't
that.
until later that they changed
Do you agree
that.
with the first DCA converted this from a cert case to a direct appeal?
Speaking of questions that you anticipate, I figured that this court was going to ask about that. I understand why they did. I think we
Isn't it better for you that they did that?
absolutely, in terms of standards of review, I think we should prevail either way.
Well,
but
I mean, if it was a cert, I mean, you did get due process in the sense, well, you got due, I mean, you're getting due process today.
Yes,
You
sir.
had notice, opportunity to say your piece, which your client did, then they got the circuit appellate just said denied. I mean, they could have just denied it or PCA'd it like sometimes we do. That doesn't mean it's a lack of due process they didn't explain. You had your opportunity to present your case, and there's certainly the high standard of cert review would be problematic for you as opposed to what we have here today on.
For second tier, I think one of the issues we'd be having to discuss was the standard on first tier review and whether the circuit court did actually
Wouldn't it be
apply the
second tier
correct law.
review?
This would be, but not the circuit court. So it would be a whole different argument with a lot of different angles. And reading the Gould decision that the First District Court of Appeal relied on, it's interesting because I see Judge Makar dissented from the decision that was made, but there was no discussion about whether or not that was proper or not to convert it to an appeal because there was never any factual question. So it was always a de novo issue of the interpretation of the statute. And so in reading the Gould decision, then I would say yes, that was the proper thing for the First District Court of Appeal to do, because under that reasoning, it was not appellate in nature, on top of the fact that, which is a whole different argument about whether or not we agree that the First District, that the Circuit Court did comply with due
Well, if you're on
process.
cert, because there's apparently difference between the second and fourth DCA on this issue, you'd lose on that on a second-tier cert, according to the Florida Supreme Court case in Garcia, where basically say, if you have a split amongst the DCAs, that means there's no clearly established principle of law, therefore there's no cert jurisdiction. And I know that because that was my case that they addressed.
Yes, sir.
I didn't
However,
particularly care for that one either, didn't think of much, but that
if you
being
look
said,
if you look at the Boulware decision, which
They
was,
win.
which was one of the decisions that was cited by the department, what the Supreme Court, what the First District Court of Appeal said, and then the Supreme Court recognized, but what the First District Court of Appeal said was the Fourth District Court of Appeal, in the Daniels opinion, or the Circuit Court may have applied the Fourth District Court of Appeal decision in Daniels, which was clearly on point regarding driver's license suspensions and whether it was a collateral consequence or a direct consequence. But the Circuit Court failed to apply the correct law that had already been determined by the Supreme Court in terms of whether or not it was, again, a penalty, administrative, and things of that nature. So in essence, what the First District Court of Appeal did, and then was subsequently recognized by the Supreme Court, was said that even if there appears to be a conflict, if one of those decisions is wrongly decided based on prior precedent from either your district or from the Supreme Court, then you would still be entitled to, that it would still be applying the wrong law.
Mrs.
And I see
Cohen,
I'm
you're
into
in
my
your
time.
rebuttal right now.
Yes,
Wanna
and if I can reserve.
Okay. It's Mr. Lynch, is that right? Yes, Your Honor. All right, sir, you may proceed.
Thank you. May it please the court.
Yes.
Michael Lynch on behalf of the Department of Highway Safety and Motor Vehicles, the appellee in the case. Both myself and my colleagues certainly agree that the issue here is strict statutory interpretation. And we both agree that to start off, Your Honors need to look at the plain language of the statute. And Judge Lambert and Judge Wallace, to your points, the statute in this case strictly states that the defendant, Mr. Miller in this case, must have been convicted 4 times of DUI before the permanent revocation provision in 322.28 2D in today's version.
Don't you have to read all the other parts of the statute under Connage and
I believe you do.
probably some paragraph out of the Scalia-Garner book that talks about doing that?
I believe you do have to consider the provision in the context of the entire statute, but certainly we disagree with the position of Jackson versus State, my colleague, that the provision at issue requires a recidivismist requirement. We do certainly believe that the plain language of the statute prevails, that so long as the defendant has been convicted 4 times of DUI, his license shall be permanently revoked.
So your clear position is, for everybody listening, if there was one case and there were 5 counts of DUI manslaughter and there was a conviction on all 5 counts, that person, based upon that one case, would be eligible for this suspension. Is that correct?
That's correct. And even if you were to change the facts slightly, even if an individual was charged in a single case from a single driving episode of 4 counts of a misdemeanor DUI causing personal injury or property damage, if that individual is convicted on all 4 counts, certainly you could say that the defendant in that case has been convicted 4 times of a DUI, of a violation of 316.193. And therefore, the statute at issue would apply, and the department, in the absence of the court doing so, could permanently revoke that individual's driver's license. That's precisely the department's position. And again, we're looking at the plain language of the statute. The plain language of the statute doesn't require separate prosecutions, as Your Honor has alluded to. It doesn't have any language requiring separate driving episodes. The only limitations or qualifications of that provision for it to apply are how many times the person has been convicted. And I believe the provision also states that at least one of the convictions has to occur subsequent to July 1st of 1982. And factually, in this case, Mr. Miller has 5 convictions. He's been convicted 5 times of DUI, arising from 2 driving episodes. 2 convictions occurred in 1987 for 2 counts of DUI manslaughter. In 1999, the defendant was convicted another 3 times of DUI causing property damage or personal injury.
From the same incident?
From the same incident. And we know from Bautista, from the Florida Supreme Court, that that is not any issue with regard to double jeopardy. So when the department receives notification from the court that he's been convicted 3 times, we can assume that those are valid convictions, that they're not listed on the DL record in violation of any sort of double jeopardy principle.
Not been set aside. There's nothing in the record that says they've been set aside.
Correct. And so the department looks at the driving record, which shows 5 convictions. It applies those facts to the plain language of the statute, which says a driver's license shall be permanently revoked so long as that individual has been convicted 4 times of DUI, and Mr. Miller has. In the department's brief, we cited the Pulaski case. It's a 2nd DCA case. Factually, in that case, it's similar to our case, although it did address a different subsection of 322.28. Specifically, in that case, it was 282, which at the time of that decision, the provision provided that upon a second conviction occurring within 5 years of a prior conviction, the court, or in the absence of the court doing so, the department shall permanently revoke the driver's license for not less than 5 years. So in that case, the individual was arrested on a single case, as the examples that we've posed to the court previously, of 2 counts of DUI. The individual was convicted of both counts. The trial court in that case suspended the defendant's license for 8 years, pursuant to 322.28282 for the 2 convictions within 5 years. So in Pulaski, it's an example of multiple counts, multiple convictions stemming from a single episode, and the court in that case clearly stated that those multiple counts from a single episode could be counted as separate convictions for purposes of an enhanced revocation period.
We don't have to follow Pulaski, correct?
That's correct. Pulaski would not be binding on this court. In fact, there's conflict among the DCAs. Jackson versus State holds contrary to Pulaski. Jackson versus State, which is a case cited by the appellant, in that case, there was an individual who was convicted previously of 1 count of DUI in 1 single episode. In a second episode, he was convicted of 3 counts of DUI. The trial court in that case permanently revoked the license based on the provision that we're discussing today, the 4 DUIs requiring a permanent revocation. The 4th DCA in that case read into the statute, which we respectfully disagree with, a recidivism requirement. So the court in Jackson is in line with the appellant's argument that prior to 322.282D ever being able to be applied, an individual must on 4 separate occasions be convicted of DUI.
So do you think we should pick a side and then certify a question to the Supreme Court, let them sort it out?
Well, respectfully, we disagree with the Jackson case, and we think Pulaski is more consistent with...
Okay, I'll rephrase it. You want us to vote, align ourselves to Pulaski and certify a question?
We would.
As opposed to voting for Jackson and certifying. Well, then you'd want us to certify the question, wouldn't you?
That would be our
That'd be a great deal.
Ms. Cohen, you know the direction this is going, right?
That would be our position. We believe the reading of the plain language in Pulaski was accurate. We believe the Jackson case, the court in Jackson, read into the statute language that simply does not exist. The statute has evolved over time. 2A2 and 2A3 now have language in there that would maybe seem to suggest that single episodes may be required, but we would note that the provision in 322.282D has never changed. From the time the department permanently revoked the license in 1999 to today, as we stand here today, that provision has always clearly and unambiguously stated if a person is convicted 4 times of DUI, the license shall be permanently revoked. And the facts support a conclusion in this case that the department did accurately and appropriately permanently revoke Mr. Miller's license due to the 5 convictions showing on his record. To address just some of the things that my colleague stated to the court in reference to requiring sequential actions, I would submit to the court that 322.28 as a whole does not employ a ladder type approach where if you drive once on a DUI, you get a 6 to 12 month suspension. If you drive a second time on DUI, it will increase. That's not always the case. And same as you go up the ladder. So for instance, to give an example, a driver who for the very first time is convicted of DUI is going to receive a revocation period between 6 months and a year. Only in certain circumstances, if that same driver on a separate episode is convicted of another DUI, will that driver receive an enhanced revocation. For instance, if I drive in 2000 and get convicted of a DUI in 2000, and then I drive in 2010, a second episode, and I get convicted again of DUI, my revocation period is going to be the same as if it was my first offense. And so that's illustrative of this statute not employing an overall recidivism scheme, which was the position of Jackson. And to go even further, you may have a situation where, for instance, if I'm convicted of 3 DUIs from separate driving episodes, again, I may, under the certain circumstances, depending on how far apart my convictions are from one another, I may have the same revocation period as a first-time offender. And so it just goes to show that not every time you repeat the offending conduct will the enhanced revocation period come into play. And so I think that calls into question the ruling in Jackson, and it was further illustrated in the Florida Supreme Court case of Stolitz. In that case, factually, we were dealing with a defendant who had been convicted of a second DUI, which was for an offense that occurred within 5 years of a prior conviction. So the statute at play is 322.282A2. That provision would prescribe a minimum 5-year revocation. However, the court in Stolitz, the trial court, permanently revoked the license of that driver, and that driver had in fact only driven on 2 separate episodes and only had 2 convictions. And so again, I believe that Stolitz it illustrates that it's not, the overall scheme of 322.28 is not about recidivism. It contemplates more than that. It contemplates the actual harm caused in a single event. For instance, if you drive drunk, you crash into a vehicle and you cause serious bodily injury, you're looking at a minimum 3-year revocation. And again, it's just a minimum. So there is a circumstance where you drive once and you cause serious bodily injury, a court can permanently revoke you. Where there are situations out there where you drive 3 times as much, you commit 3 times as many driving episodes, and you only have a 1-year revocation. And so in total, we believe, based on the facts of this case, the trial court made the appropriate decision. We would ask this court to affirm the trial court's decision and find that the department properly permanently revoked Mr. Miller's license.
Thank you, counsel. Mrs. Cohen, you have a little less than 5 minutes. My first question out of the chute is, why should we not follow our colleagues on the second DCA in the Pulaski case?
Because if you read Pulaski, there were 2 cases that they cited in Pulaski. The Bender decision, which the issue in the Bender decision was they changed the number on the DUI statute. It went from 316.028 to 316.193. And so Mr. Bender argued, well, you can't count my other convictions on other dates because they were under a different statute number. So that clearly was not factually the same thing. They talked about the language of reading the statute. And if you read the Bender decision, they actually talk about the concern about repeat behaviors. So Bender, if you look at the reasoning of Pulaski, by citing Bender, the reasoning in their result doesn't follow what was in Bender. Same thing with Mitchell. The other decision they cited was the Mitchell opinion, but again, those were separate offense dates. He was sentenced on the same day, but those were separate offense dates. So if you look at the rationale and the reasoning in Pulaski, then you see that they came to the wrong decision. Whereas if you look at the reasoning in Jackson, they actually went through the language of the statute, which if you, responding to counsel's argument, I would start with Stolitz. First of all, it's important to understand the distinction between the authority of the department to act, because they're an administrative agency and they can only do what the legislature tells them they can do, and the authority of a court to take a different action. And correctly, a court can impose a higher suspension if there is no maximum suspension listed under 322.28, but the department cannot, and the statute very specifically directs the department that on a first conviction, they shall impose the maximum, which is a year, if the court does not. If the court does not on the others, however, and then they refer to a second or subsequent conviction, then the department must impose the minimum set out in the statute. So Stolitz does not give the department any authority beyond what it has specifically laid out in the statute, and Stolitz does not say that the department can change a suspension. And again, even using the examples that the department has given this court, clearly the legislature has chosen to make decisions that we may not agree with. We may not agree that if you get arrested 3 times for DUI and you happen to get 10 years in 1 day, you're back to 6 months or a year. We may not like that. We may not agree with it. But it's not our decision to make. It's up to the legislature. And so the legislature has set out how it directs the department to impose suspensions under certain fact patterns, and it includes that sequence in every one of them. And also I think for whatever it's worth, and while whether or not these were manslaughters or they weren't, really should not enter into the calculation because that's not part of this part of the statute. That part of the statute has changed altogether. So we're really talking about, like the suggestion in the example I gave, it can be hitting 4 mailboxes versus hitting 1 person, and your penalty is greater. It could be any of those things. And so taking that aside, and the other thing I wanted to add was, while we're not disputing the fact, this is not about the facts, one thing that the department noted was that the department's permanently revoked the license in 1999, as addressed in the hearing very below and in the documents that are contained in the record regarding the certified driving record and the uncertified driving record. It appears that the department actually added it to the record in 2013, which is interesting because it was about a month before the amendment to the statute where the legislature went in and specifically said separate offenses, even if convicted on the same day, count as separate convictions, but they were very clear that it was on separate days. And so I don't know if that's coincidence, if that caused an audit or what caused that, but if you look at those items in the record, which are contained, and I apologize, I thought I'd written the page numbers down for those particular items that are contained in the appendix from the original argument. Clearly, it didn't happen until 2013. I don't know what that difference that makes in terms of the discussion, but just to clarify that in terms of the facts set out. And if there's no further questions, I think that's everything.
All right,
And
thank you.
more.
Thank you,
Thank
counsel. It was well argued on both sides. And Ms. Cohen, while you're up, why don't you, could you give the students a benefit of your background?
Yes, sir. I was born and raised in Gainesville, so preschool to law school. And after I graduated from the University of Florida undergrad, I went down to South Florida for a while, and I was a parole probation officer. And when I was in college and when I did all that, there were certain things that you learn about the entire criminal justice system, and that is where the power lies and how you can become involved in that. And I ended up going to law school because I wanted to be a prosecutor. Because the judges can only rule on cases if the prosecutor brings them, and the prosecutor has a lot of control, a lot of power, but you have to have the respect for the fact that you have all that power. So I was a prosecutor, and particularly I was interested in juvenile prosecution because the issue of juvenile that commit law violations, it's an issue of protection of the community, but also how do we make sure that this doesn't happen again, and how do we address whatever needs there might be for a kid, because your issues are clearly very different than adults. At one point I had a child in high school, a child in middle school, and a child in elementary school, and I was going 8 million different directions, and my current boss came and talked to me, and he said, why don't you come do appeal work in my office, post-conviction, which is after certified certain motions, come work in my office. And so while I, at the point, was like, I could never do that, that's so boring, because what my kids were doing, and because I had so many things that I was active with my kids, I went ahead and did that, and that was 20-some-odd years ago. And so I've been there ever since. And I do some of the trial work, but like the other gentleman before, a lot of times in my office, I called upon if there's motions to argue, to do these appeals, to do that sort of thing. I also handle some cases from the defense standpoint for some of the trial work. And you get a very different perspective, and when you work both sides, and it's very beneficial to have both of those perspectives because you're dealing with human lives, whichever side you're on. So that's a little stressful. And so I've been doing that ever since. My kids obviously are grown. I actually have a kid in Seattle. And so I'm trying to think of what the other thing, in terms of getting ready for today, my brief wasn't as long because, as y'all could probably figure out, the issue was a little more narrow than the other case, and the facts were just really not as significant because there was no dispute about the facts. We agreed this is what the fact is, what does it mean under the law? So, but even with that, I took several days where I focused totally on that. Of course, my grandchildren were in Orlando on Saturday, so I did go to the water park on Sunday. But other than that, I spent several days getting ready for today. And in terms of the briefs and everything like that, you have to, even if you do a lot of it and you know stuff, you have to check the cases every time because something may change, another court may say, no, that case isn't good law anymore, and you don't want to come in here and argue something and have one of these gentlemen say, that case isn't good law anymore. So you have to make sure that you get prepared for everything. I don't remember what the rest of that.
That's good.
Thank you, Mrs. Cohn. And Mr. Lynch.
Yes, good morning. My name is Michael Lynch. My uncle was a lawyer, and he had told me about all the stories, cases that he's tried and clients that he represented. I felt that it would be a career path for me that would be very rewarding, and it's exceeded my expectations entirely. And so after undergrad, I went to law school right in Orlando at Murray University School of Law. I actually still reside in Orlando. I've been there since, I would say, roughly 2010. But my first job at a law school was as a prosecutor in the 18th Judicial Circuit, which is comprised of Seminole County and Brevard County. When I applied, I was hoping I'd get a job in Seminole County as I resided in Seminole County, but the only opening they had was Brevard. So for the next 5 years, I commuted to Brevard every single day for work as a prosecutor. I started off in county court where you prosecute crimes, second-degree misdemeanors and first-degree misdemeanors. So we might encounter cases where an individual driving on a suspended license, has small quantities of illegal drugs, or driving under the influence, as you heard about today. Eventually, I was promoted to circuit court, where you handle more serious offenses that are punishable by prison time and things of that sort. It was a very rewarding experience.
What type of cases? You mean like robbery and
Yeah.
murder and stuff like that?
Exactly. When you get up to circuit court, you handle anything from, you can handle grand thefts where the individual has stolen a certain money value.
Stole a car or something like that?
Yeah, grand theft, motor vehicle, where an individual steals a car. Homicides could be anything from a DUI manslaughter, where maybe there's not an intent to kill, but you committed an act which caused the death of another individual. Or it can be a first-degree premeditated murder, where somebody had a plan, put that plan into effect, and took someone's life. So it's a broad range of cases with a very broad range of possible punishment for the individuals that are accused of those crimes. And so it's a heavy weight to have on you, but keep in mind that what you're doing is going to protect the community. It's going to have a great impact on the victim's life that you're in essence fighting for in court. It's an extremely rewarding experience. It's something that I would do again if I had to start over. And the trial experience that you get is unmatched. To be able to stand in front of a judge almost on a daily basis is certainly an experience that I would recommend to anybody interested in getting into law if you have those aspirations.
Depends on the judge, though, doesn't it?
To some extent, yes. Not everything in court's going to go your way. That's part of the job. You learn to live with it. You always do what you feel is right. Certainly as a prosecutor, you never want to mislead the court. You always want to follow the law and apply the facts that you have in your case to what the law is. Sometimes you get the outcome you want. Sometimes you don't. That's just kind of the nature of the beast, as counsel said earlier. After my career as a prosecutor, I actually had my first son. His name's Grayson, so I let me name him. I had my first son, so that brought me closer to home. I wanted to look for a job that was closer to Orlando. I was tired of staying at the office till 7, sometimes 8, preparing for trial, and then having that hour-long drive home. So in order to see my son a little more, I looked for work closer to home. I began my employment with the Department of Highway Safety and Motor Vehicles. It's a very broad department that has a number of different divisions within it. One division is the Florida Highway Patrol. I actually started my career with the department as a troop legal advisor for Troop D, which encompasses 6 different counties within Central Florida, actually including Volusia. And so as part of that job, you provide 24/7 on-call legal assistance to the members of the Florida Highway Patrol. I developed trainings and presented trainings to them just to ensure that they're doing what they should be doing. And it gave me an opportunity to employ my skills that I had learned from being a prosecutor in that criminal law world, and also kind of get some experience into the civil realm as well, doing civil asset forfeiture, where you can take property that's used in the commission of certain felony offenses or the proceeds of criminal activities. And so it was kind of my segue into...
So like if some drug dealer is found with a bunch of money, then and that's from the sale of drugs, you guys would pursue getting that money as well as prosecuting him for committing the crime?
You would, yeah. In those cases, you have 2 separate proceedings that are kind of going on at the same time, and they're both separate and distinct. So you might have an individual who's charged with we'll say, trafficking in some very serious drug, that when he's arrested, he's got, a sack of cash in his trunk. And the law enforcement agency will, of course, arrest the individual for whatever offense it is that they feel the facts support. And the law enforcement agency can also seek civil asset forfeiture of that cash, so long as we can prove that the drug use or drug transactions has some sort of nexus or connection to that cash. So it's not that you can just take people's property, you've got to prove that it's either the proceeds or it was used in the commission of that offense. And just like in criminal court, where that individual would have a jury trial if they so choose, in a forfeiture proceeding, again, it's basically a lawsuit against that property. The property owner has the opportunity as well to have a jury trial. We would have to prove beyond a reasonable doubt, just like in the criminal case, that that property was used in the commission of the offense or as proceeds of the offense. And so I did that for roughly 2 years, and then kind of found myself in this position now where I essentially defend the administrative actions of the department when it comes to suspension, revocation, cancellation of driver's licenses. And so this is one of the aspects of my job that you saw today. I hope you enjoyed the presentation. If anyone has any questions.
All right. So just counsel question to both of you. How many times, Mrs. Cohen, have you appeared in an appellate court setting such as this and argued cases? If you can estimate.
In district, I've been in the Supreme Court several times.
Florida Supreme Court.
Florida Supreme, yeah. not
Okay.
federal. Florida Supreme Court several times, sometimes even successfully. I've been in the First District Court of Appeal,
That's,
probably 10 to 15.
that's in Tallahassee. And
That's in Tallahassee. And then on the circuit bench, in Duval County and in various counties, that's a lot.
Okay. All right.
Yeah, I'm fairly new to this. So this was my first appearance in front of the District Court of Appeals. I've never appeared in front of the Florida Supreme Court. As a prosecutor, when you practice in county court, if there's an issue or a perceived issue by one side, for instance, if an individual is convicted of a crime and the defense feels there was some sort of issue that was occurring during the trial, they can preserve that issue for appeal. And at the time I was practicing in county court, the appeal would go to a circuit court bench. So similar to what you see here, but on a circuit court level, you have a panel of 3 judges just like this, and you would be able to brief the issue that arose in the trial court and then present oral argument just like we saw today, just in a different venue in front of circuit court judges. So I was able to do that twice, thankfully successfully, and this was my 3rd appearance in the appellate court.
Mr. Lynch got his start at the 18th Circuit as an assistant state attorney. I did too. I was in Seminole County, and Mrs. Cohen was talking about juvenile court. I was assigned to juvenile court as my first assignment, and I had no children, which now that's changed. I have 2 of my children that are now in the gallery today, one of whom is Grayson, who asked the first question. So, yes, in my...
He's planted people in the audience.
Yes. Yes. And my daughter, who I introduced for the first time today, not as Caroline Wallace, but as Caroline Quinlan. So that was a gut punch for me. But congratulations, Caroline. So...
She's married, not because she wanted to change her label.
So, okay. Somebody have a question for Mrs. Cohen?
She's going to direct.
Okay. All right, to Mr. Lynch. Go ahead.
What is the biggest case you have been a part of?
The biggest case.
Today.
Yeah. Today was a big moment just because it was my first opportunity to present argument to a 5th District Court of Appeal. I'm thankful to be here in person. I know there was an opportunity to appear remotely, but I thought to have the full experience being in person was excellent. So this experience has certainly been a moment in my career that I'll remember. But if I had to choose a case, I would probably go back to my prosecutor years. Towards the end of my prosecution career, I tried a DUI manslaughter case. The facts were very difficult. We had a blood result in that case, so the individual was eventually arrested. Not on scene. So DUI manslaughter sometimes are a little strange. Not all the time is the individual arrested at the scene of the incident, because sometimes law enforcement, for various reasons, will want to wait to get the blood test result back to see what the person's breath alcohol or blood alcohol content is, and whether it's above 0.08, which is the legal standard in Florida. And so there were a lot of intricacies in the case that made it very difficult in terms of proving whether the person was under the influence to the extent that their normal faculties were impaired, or that they were driving with an unlawful blood alcohol content, because in this specific case, the blood sample was taken pretty far after the event had occurred. And so there was an argument from the defense that whatever the blood result was not necessarily the blood result at the time of the crash. And so it was undisputed, obviously, that a death had been caused, but the issue and the argument in the trial was over whether the person at the time of that crash was under the influence to the extent that their normal faculties were impaired or above 0.08. And so it presented a tough challenge for us. We actually tried the case, and the first time we tried it, we got a hung jury. It was a mistrial, which means you basically get to try the whole thing over again, because we didn't have a jury come to a unanimous decision. So they would not all say guilty, and they would not all say not guilty. And so that added another level of difficulty to it, because now you've got to put this victim's family through this entire process over. And so it's sort of a gut punch to the prosecutor, because you want to do everything you can for that family, and you have this overwhelming feeling of failure because you didn't get the result that they wanted. Ultimately, that case ended up resolving short of a trial. The family, for various reasons, didn't want to go through the process again. An offer was made to resolve the case, and the defendant accepted a plea resolution. And so I would have to say that was probably the most difficult case, just because the facts were very difficult to use for the prosecution, but even more so just the feeling of maybe I could have done something different to obtain a better outcome for the family. So I would say that was probably, from a professional and emotional standpoint, probably my toughest case.
Thank you. Any question for Mrs. Cohen? Yes.
I have one for both of you, if you don't mind. What does a typical workday look for both of you, and how many hours do you think you work a week? On average.
I would suggest that my typical workday is probably very different than his typical workday. It's also, just so y'all know, nobody's asked, but we work together on a lot of cases. And on TV, you see the attorneys are like at each other's, and that's just not how it really is. We get along. This is actually my first time, because he's going to meet him in person, but we communicate and we talk. And so we have a much better relationship. It's not like on TV where it's like, oh my God, don't trust him. But aside from that, my work day, because I do so many different things, especially now because like everything else in the world, we're short an attorney, so I'm doing a lot more court work. So I go to court in the morning and I see the judge about cases that I'm working on and trying to get witness information, things like that. And then you're talking to witnesses, you're doing research. Everything is in Duval County. Our sheriff's office has body cameras and DUI videos, so hours watching body cams and DUI videos. And then I may go and do the type of hearing like this case is related to. In the department, we go have a hearing about somebody's driver's license. And so most days run very long now. And then sometimes I have to take days and work on stuff like this. So for me, it's pretty much I'm doing a lot of different things, talking to prosecutors, doing a lot of different things.
Yeah, mine's a little bit easier these days, but it's still difficult nonetheless. And so I would probably say it's fair to say that my position is more of an 8 to 5 position than Mrs. Cohen's case. I come in at 8. For the most days, I leave at 5, but there are days where there's just not enough time during the day. You got to stay a little late. My day is predominantly spent researching and writing, preparing for cases like we saw today. It could be answering questions from individuals like Mrs. Cohen that are calling saying, hey, this is an experience my client had, can you look into it? And sometimes we'll look into it to kind of avoid getting to this stage if we can. That's predominantly my day is researching and writing. Every so often, they will have me conduct training for the department. So when that day comes, I prepare the training and present it. But most of my job is just researching and writing. I will say it's much different now than the early stages of my career as a prosecutor. When you're a prosecutor, the caseloads are overflowing. And so at any given time, you may be responsible for upwards of 150 cases. On top of that, new cases are coming in. And so you've got work while you're in court almost every day, sometimes for the entirety of the day. You've still got work coming into your office. And so oftentimes you would get out of court at 4 p.m., you go back to your office and your desk is full of things that you have to do. And so it was not uncommon that I would find myself staying much later after 5 just to be able to get the work done and stay ahead. And so that's kind of been my experience in terms of work-life balance for the different positions.
All right, we're going to take the break. I just want to confirm with our marshal, we're in the library, correct?
Yes, sir.
Okay, so I'll invite everybody to go to the library. We'll be with you shortly. We do have one more case that we're going to handle after the break. But we'll see you in the library in a few minutes, and we're in recess.
Counsel, you're not compelled to do that. If you'd like, we'll visit with you, but we're just inviting you. But if you got other things to do, thank you for coming.
Remember the scene from A Few Good Men?
Oh, I didn't
When they
see
walk
that.
into the courtroom? And then he says, I'll flip you for it.
Unfortunately, I think I have to go first.
All right, you may be seated. Okay, the final case this morning is Darlene Peoples versus Community Rehabilitation Center, Inc. And I am going to assume from the appellant that you would like 5 minutes of rebuttal. Ms. Lawton, and is that correct? Yes, ma'am. Okay, all right, you may proceed when you're ready.
Good morning, Your Honors. May it please the Court?
Yes.
My name is Lindsay Lawton. I represent Darlene Peoples. My client, Ms. Peoples, was the plaintiff in a claim under the Florida Whistleblowers Act. The issue on appeal is whether the trial court erred in granting summary judgment for the defendant, Community Rehabilitation Center, or CRC for short. There were two disputed elements below. The first was whether Ms. Peoples engaged in protected conduct under the Whistleblower Act, and the second was, if so, whether that protected conduct was the reason she was fired. The trial court correctly declined to premise summary judgment on the first element, but the trial court erred in concluding that there was no genuine dispute of material fact as to the causation element. Since Ms. Peoples won on the protected conduct element, I intend to focus on the causation element this morning, but of course I'm happy to answer questions on either element.
So, Ms. Lawton, the focus of the case from your perspective is that the reason why your client was fired from her position was because it was a retaliatory action by the employer. Is that correct?
That is correct, Your Honor.
Okay, and the retaliatory action was your client. I believe the theme of your case is your client was making complaints or expressing concern about not being properly licensed when she changed position from within the company that she was working for. Is that correct?
That is correct, Your Honor.
Okay.
In addition, that she complained about the safety of requiring her to go out to patients' homes and render mental health services, or at least be expected by the patients to be rendering mental health services when she was not qualified to be a mental health counselor.
Well, I believe you said the safety, but I believe a major component of your position is she wasn't properly licensed to be rendering the mental health care that she was providing or being asked to provide to the new department that she was moved into. Is that correct?
Absolutely, Your Honor. I mentioned the safety because that is a second violation of the law that CRC was engaged in, that Ms. Peoples was complaining about. So there were two. First, she lacked the licensure or the training to be a mental health counselor. And second was the environments she was being sent out to were unsafe, and CRC had done nothing to mitigate the hazards that she was experiencing.
Was she being sent to an unsafe environment that other employees in that field were not being sent by CRC? In other words, were her colleagues being sent for mental health counseling in similar scenarios?
Yes, Your Honor. The other people that CRC was calling mental health counselors were also being sent into similar environments.
Right. So the retaliation is not, well, we're going to send you to the dangerous places and nobody else has to do that.
Oh, no, Your Honor. The retaliation was firing her after she repeatedly said, I don't have the training to be doing this and it's unsafe for me to be doing this.
So why couldn't they say, okay, then, if that's how you feel, then we'll let you go? I mean, because again, she's what they call in Florida, she's an at-will employee. She has no contract with them. So in theory, before we even get to the lawsuit, they could have, the CRC, the powers that be in the CRC could have awoke one day and say, we're going to clean house, we're going to fire these 10 people, and Ms. Peoples happens to be one of them. They could have done that.
That's right.
And they didn't have to give a reason. They could have said, thanks for your effort, but today's your last day. Good luck. We'll hope for the best, right?
That is correct, Your Honor.
There's no actionable, she doesn't get to sue them saying, that's terrible, I really like my job, and I didn't want to leave.
Correct. As long as they fired her for a non-retaliatory reason,
Right.
then...
So they never said anything, just woke up, like I said, today was the day, saying, guess what? You go tell Ms. Peoples she's no longer going to be employed after today.
Well, Your Honor, it doesn't require the employer to say something to be found to have taken the adverse personnel action in retaliation. These cases are often proved on circumstantial evidence. So even if CRC didn't say anything that incriminated them, so to speak, Ms. Peoples might have had a case.
Well, let me add more. So let's say she was still working in the other counseling position, not the mental. She was working her job that she was always working, was happy with it. What was the nature of that counseling she was providing before? Alcohol-related counseling?
Substance abuse.
So in other
yes.
words, if they came in, there's nothing in her personnel file, they just came in one day and said, you know what, we've made a decision to terminate you. And that would be fine.
That would be fine, Your Honor, as long as there was no evidence to prove that their true motivation was...
Well, under my hypothetical, there's nothing in the personnel. Nobody's said anything. Nobody's done anything. They just said it's time we're going to cut. In other words, today I could walk in and say to my 2 staff attorneys, you know what, we're going to save money here. I'm going to have to let you go. You've been great employees, but have a nice day. Good luck. I hope for the best for you. They can't sue me, or they can't win against me. I guess they could sue anybody about anything. But
That is correct, Your Honor. I agree with your hypothetical. Under the hypothetical scenario you've outlined, there would be no legal cause of action.
And in this case, their argument is like, well, we had concerns about her productivity that we have documented before any of this came up about her unhappiness in the shift from counseling and alcohol field to the mental health. That's whether you agree with it, that's their position, right?
That is part of their position,
And that's
yes.
certainly legitimate, non-discriminatory, non-retaliatory reasons saying, just like if I'm in a law firm and I say, I'm going to let go of this associate because we're not making any money with this associate and he or she's been with us for 2 years and it's perhaps time for them to take a different direction.
Yes. If they had actually fired her for low productivity, then there would be no cause of action.
Well, that's what they say they did. I mean,
That is what they say they did, but Ms. Peoples has evidence that there were other motivations, or that was not the true motivation.
it has to be but for. I mean, in other words, it can be linked. They could say, boy, she's really getting tiring, or boy, but we, early on before this all started, she's not productive. And that's why in fact, she was on a termination list, if I understand. I know you don't like the date of the document, but let's assume that was just a misdate. They didn't write a letter 3 years before she ever came there.
Well, Your Honor, even if we don't consider the issue with the date of the document, that there's still a disputed issue of fact as to whether there actually was a termination list. They claim there was a termination list, but they never produced any such list. A jury would be entitled to weigh that.
Well, did you move to compel it?
Your Honor, I don't know if there was a motion to compel that termination list.
Well, I mean, it's one thing to say, here's our position. We have a non-pretextual reason why we're terminating her. She's on a termination list for lack of productivity. We decided, their position, we decided to give her a second chance in a different area and try to train her, and that didn't work out, so we ultimately let her go. But, in the context of what we are in the whistleblower thing, we have to look to see if we're at the last step here. We'll give you the benefit of the doubt of all the steps. We're at the last step. Is the reason pretextual or not? Is there enough to go to a jury? Mm-hmm. And there is documentation that suggests that your client was on the termination list. Whether it was produced or not, that's an event that could have been remedied by the trial court if requested to say, if you have a list, produce the list. If you don't produce the list, then you don't get to argue that. Isn't that kind of how things go? And I know they speech when I was a trial judge for all those years. So, yeah. That's what I'd have done if I was me. How about that?
Well, a summary judgment motion is decided on the summary judgment evidence that's before the court.
I get all that, but I'm saying, you made it sound like it's skeptical whether there was a list. If there is a list that says Darlene Peoples and these other people are on the, quote, termination list, and this is before she is being transferred to another division she's unhappy with, she thinks she's not trained for, not qualified for, and she's complaining about it. I mean, that's the premise, is that I'm being fired because I'm complaining that you're putting me in a job that I'm not qualified for, and it's dangerous for both me and the patients because I shouldn't be doing this. And now that I've raised this as a question, you're firing me just to keep me quiet and shut me up and push me out the door. And therefore, I should be awarded damages under the whistleblower. I mean, that's what your case is. I mean,
That's exactly it, Your
I
Honor.
mean, you plead it better than I talk it, probably. But I mean, if there is you have to show that to prevail or to avoid summary judgment, that there is the only reason for the termination is the improper retaliation, right?
Correct.
But for under St.
Yes.
Mary's, the
Yes,
Supreme Court. I mean, they clarified that.
correct. And, well, the standard is but for causation.
Yeah, so
But
but
for
for.
Ms. Peoples' complaints about her lack of training and safety, she would not have been fired on September 5th, 2016.
Was the lack of training, that's not by the letter of the law, a criminal or a violation, is that correct?
It is a violation of the ACA regulations, or the regulations that, under the ACA handbook, that CRC was bound by. Is an administrative rule. Is the
So
word I'm
were
looking
all
for.
of the other then counselors that were in the Ryan White section, was CRC also in violation based upon the lack of licensing of those employees as well?
As far as I understand it, Your Honor, yes. And I submit that is part of the reason why CRC would have been so upset by Ms. Peoples' complaints, because she was revealing a defect in the way they practiced,
Was that argument presented to the trial court,
that the other mental health counselors were not.
also in violation?
I don't remember if that specific argument was made, but I believe the overall effect of the facts of the case show that that would have been a motivation for the firing, which is part of the circumstantial case.
If there's no termination list, my hypothetical, if there's no termination list and the supervisors or the powers that be in CRC say, you know what, I think we want to move Ms. Peoples from the alcohol counseling group to the mental health counseling group, and she says, I don't think I should do that, it's not proper, I don't have the proper credentials or training or education, whatever reason, okay, and if they say, okay, thank you, Ms. Peoples, then we're going to have to let you go, is that an actionable event? Forget about whether anything that happened before then. Nothing happened. She's just been an employee, and they decide to shift her, and she says, I don't think I'm qualified to do that. I don't want to do that. It's unsafe. And they say, well, if that's how you feel, that's okay, Ms. Peoples, then we're going to have to let you go. Is that actionable under whistleblower?
I think, Your Honor, it would depend on what additional facts existed.
Those are the facts.
Those are the facts. Is that in and of itself, that is not actionable because, well, I think those facts are ambiguous, Your Honor.
Are they?
Yes, because it's not clear under the scenario, as far as I'm understanding it, whether in the hypothetical, when CRC moves her to the mental health counselor position, is it because they can no longer use her as a substance abuse counselor? Are they telling her, we don't want you to be a substance abuse counselor, but we're going to offer you this new position? And she says, I can't take that
We
position.
think you've been a good employee, but we think you could provide better service to our customers in the mental health field. You're very talented, and we're going to ask you to go here or direct you to go here. And we think you'll be the best one there, even though we have other mental health counselors, and your client says, respectfully, I don't want to do that. I don't think I'm qualified. Can't the CRC then say, okay, that's Ms. Peoples' choice, that's fine, then we choose to let her go? Like, can't they do that? Can't they do that without being sued and try to get damages against them?
If they had no illegitimate reason for moving her from substance abuse.
Those are the reasons. It's one of the beauties about being a judge. I guess I like being a judge after all. You get to make up these things and say these things. But obviously, it's to explore the issue of law that we're talking about.
Yes, Your Honor, I appreciate
It's not just for laughs today. It's to understand what the principle that you're under and guiding and how that applies broad-based depending on what we do here and what we write, or if we, things of that, and you understand that.
Yes, Your Honor. So the principle of law is, as you know, they can fire her for any reason as long as it is not an illegitimate retaliatory reason. And so under the facts that you're describing, it is not clear to me whether it would be an illegitimate retaliatory reason. It sounds like to me, Your Honor, you're saying they determined in this hypothetical world that they didn't need her in substance abuse anymore and offered her a new position as a mental health counselor, and she declined it. I don't think that would be actionable, but that isn't what we have here. What we have here is she said, I'm willing to do the job for you if you want me to with training. They would never expressly agree that she wasn't qualified for it. In fact, to this day, I think they assert that she was qualified for it. And so even if they might have had some legitimate reason for firing her, that isn't what they did. They fired her because she complained about lack of training, while they still believed that she did have, or at least purported to believe that she still had the training, and kept other people who lacked that training in the role, including Ms. Halima Scurry.
Wasn't there a June 2016 employee status payroll change document that documented the concern as far as your client's productivity within the company? Specifically, that document said you can maintain your current payroll level as long as you, in transferring to this new department section, that you increase your productivity, and she was given some parameters for that productivity expectation. Is that correct?
I believe what they said was not as long as you increase your productivity, but you increase the caseload of the Ryan White program. So even when Ms. Peoples went into that position, the Ryan White program didn't have the number of patients that CRC wanted. And so they took her, allegedly because she was not productive in her prior position, and they said, come to this other program that is failing and make it better. And if you don't, we're going to dock your pay. That is my memory of what the record said about the productivity. There was some.
You're in your rebuttal time, but I'm sorry to ask a question and then tell you you're in your rebuttal time. You may answer the question. I may give you some additional time. So. Thank
you, Your Honor. I would like to answer that question. So there were some references, it may be in that same document you're referring to, about insufficient billing or something. But one thing to remember is, even if we assume that it's true, which I submit to you based on the arguments today and as more thoroughly discussed in the briefing, that there was certainly a jury question as to whether there was ever a termination list. But even if we assume there was one and that they found her low in productivity in June, she wasn't fired until September. Had they fired her in June and said it was for low productivity, we wouldn't have an issue. But what they did was they kept her on, and she complained about their policy that was violating the ACA handbook, and they decided that that was too much. And their termination memo actually references the fact that she was talking to Gaffney and Goodman. What was she talking to them about? She was talking to them about their violation of the ACA rule. And the Alvarez case cited in the briefing from the 11th Circuit supports that, the argument that had she been fired in June for low productivity, that would be one thing. But she didn't. She wasn't fired then. She was kept on, and they developed an illegitimate purpose for firing her. And if there are no further questions at this time, I would like to save the remainder of my time for rebuttal.
Okay.
Thank you, Your Honors.
Good morning.
Good morning. May it please the court. Again, my name is Jack Webb. I am counsel for CRC, that's Community Rehabilitative Centers Incorporated, located in Jacksonville, Florida. At the outset, reviewing the briefs here before the court, counsel in her closing point cites to the Alvarez case as to the timing of all of this. That is somehow in the Alvarez case, my understanding of the facts is that the employer had made a decision or had considered firing the controller, the individual, and then the day before they were able to execute that, the individual, the employee, filed a charge of discrimination. At that point, the employer was fearful of sabotage or something along those lines, so it proactively acted. Okay, again, the court in the 11th Circuit in Alvarez didn't necessarily say that that was dispositive as to whether or not it was retaliatory. It said it created an issue of fact because, again, the court even said, I think it was Judge Branch, who stated that, all right, you know, if there's a legitimate concern here as to retaliation, or excuse me, as to sabotage, that may justify the termination. But again, at this point in the record, they did not raise that. The employer did not raise that below. So, okay, we're going to kick it back and we're going to consider that issue. It's almost as if the court ruled that, all right, you took an adverse employment action and it clearly was retaliatory, but is there an affirmative defense to the retaliatory action? So that was the issue in Alvarez. So I just want to distinguish that. But
let me ask you this. If we jump ahead under the McDonnell-Douglas, we're down to the third prong, and I think your opposing counsel concedes that your burden of production was met, that there was a legitimate non-discriminatory reason be set forth, i.e. you're not very productive and we're going to let you go.
Correct.
Is it your position that basically when the burden shifted, or the burden reshifted back to Ms. Peoples to show that that was pretextual, that there's just an insufficient record presented to justify it going to a jury under our new summary judgment standard? In other words, if the record had been developed more that says, well, wait a minute, you're saying that I'm not productive, and that's the legitimate reason why you want to fire me, and now we look at all of my colleagues in the same department, and I'm the most financially productive of everybody, so this reason is pretextual, and therefore it should go to a jury, and therefore summary judgment shouldn't be granted. I mean, is that the position?
No, Your Honor, that's not the position. Our position is that the record that was developed below is full. And again, to the extent that the McDonnell-Douglas shifting burden analysis is applied properly, okay, we met our burden of production, okay? Now it shifts back to Ms. Peoples to, okay, poke a hole in my argument. Show me, show the court.
I thought that's what I was throwing you, the softball, that she didn't.
She did not.
Right, but I mean, she could have.
Well, she could.
If there wasn't enough to show to the trial judge, apparently to the trial judge's satisfaction, that the reason being given, her lack of productivity, is false, and it's not the reason she's being fired. She's being fired because she's complaining about the violations being committed, about forcing her into a job that she's not qualified for, so that became the problem for Ms. Peoples below, and as it seems like your argument here would be the same problem she has here.
Your Honor, what they're arguing here is basically a rehash, a restatement of the record below, because the record below clearly established that, again, with regards to the purported violations of the OSHA General Duty Clause, well, after Ms. Peoples complained that there wasn't sufficient training, or she didn't feel safe under, pursuant to the OSHA requirements, that CRC had a meeting and it brought all the clinicians in.
Wasn't there a response? I guess there was a recommendation from the chief operating officer that Mrs. Peoples and other employees go to this training with Heather Vaughn.
Heather Vaughn?
Heather Vaughn, V-A-U-G-H.
There were, Your Honor, there were efforts to go above and beyond the requirements as,
Well, specifically, we can talk about other efforts, but I'd like to focus on this training. There was a recommendation that she go to this training with this Heather Vaughn, and the training never took place. Is that correct?
No, that's not correct, Your Honor. I don't believe that's the case. I believe that that all of the required requisite training, in addition to the additional efforts.
On page 1539 of the record, there is the allegation that the training with Ms. Vaughn never took place. Is that accurate?
I do not believe that is accurate, Your Honor. I do not believe that's accurate. My understanding of the record is that that all of the requisite training and was provided to her pursuant to Deirdre Kelly, who was responsible for administration of the Ryan White program for the city of Jacksonville. I think the record further reflects that after, I think it was Erica Goodman, had a conversation with Miss Kelly at the city of Jacksonville, she reached out to I guess, whatever the state administrative agency is to clarify that they were doing everything right with regards to providing the appropriate training. I'm sorry, Your Honor?
But Ms. Kelly is not Mrs. Vaughn, correct?
That's correct, Your Honor. She is not.
What's the significance behind this, the dating of this, I guess, email? It's June 14th, 2010, or June 14th, 2016?
That's a great question. I mean, Your Honor, it was apparently, well, clearly, Ms. Peoples was not employed with GRC in 2010. So it was a typo, apparently. And
Pretty big typo to hang your hat on with regard to facts of this important case.
well, Your Honor, we had produced, as the court probably well knows, this case has been going on for a long time, and there was a lot of discovery propounded in this case. And we produced that, I believe, back in I think it was it was very early on in the case. And there were some allegations raised as to its authenticity at the trial court, at the hearing and the motion for summary judgment, Your Honor. But there were questions, I think counsel at the time questioned what we just got it the other day. Well, that wasn't the case. The trial court judge asked at summary judgment hearing, well, did you ever request it to be authenticated? And then trial court counsel did not know. But the record reflects, Your Honor, subject to the transcript, that I informed the court that it had been authenticated pursuant to a request for production that was propounded by Ms. Peoples' counsel. So there was no issue below, there was no credible evidence issue or before the court as to the fact whether or not it was not authentic. It was not authentic. But that said, as the court previously asked, there was a subsequent employee update memo that reflected the low productivity. So there would be, I would argue, there would be no question as to doubt the veracity of the contents of the document, notwithstanding.
Those two documents predate any transfer of Ms. Peoples to the Ryan White program?
Yes, Your Honor.
Okay, so your position is the evidence before the trial court for summary judgment purposes showed that before there was ever any discussion about this transfer that became problematic in Ms. Peoples' minds, that it was already being discussed that we may not keep her as an employee because she's not productive she's not making money.
That's correct, Your Honor.
Not a matter of is she trying hard or is she good at accounts, she's just not financially productive, and you're not a public entity, you're a for-profit entity, I assume.
That's correct, Your Honor. It's a nonprofit.
Right, well, I mean, you're still, obviously you don't try,
yes,
you don't try to lose money.
Sure, I can't afford to, yeah. Yes, Your Honor, that's correct. And it's interesting in that when Ms. People, I think the record reflects, when Ms. People was first approached, brought in and counseled on this issue, she said, listen, we're gonna move you over and we're gonna do this. You are a master's level clinician at this point and you are qualified to do this. She didn't object to any illegality. She didn't object, say she wasn't properly trained. She just, I don't want to do this. And so the narrative somewhat evolved over time, which is fine, but it all evolved over the time subsequent to the employer's, CRC's, documentation of the productivity issues and the need to move her. That said as well, she was informed, Your Honor asked a couple of questions about the employment at will status, and her employment file reflects the fact that there's an acknowledgement of employment at will status, and she was told at the time of that initial meeting that if you don't take this, if we don't move you, we are going to have to terminate you. In fact, the record further reflects the fact that the reason that they did not terminate her at that time was because she was, in fact, a single mother, and she had financial issues, so let's do what we can to work with her. And the record further reflects continued efforts to develop her, whether through additional training, gratuitous training nonetheless, but training to develop her skills as a master's level clinician and make her a valuable asset to the
But
employer of CRC.
That's not really the standard, though. I mean, the fact that there's evidence that would support your position for purposes of the summary judgment, you know, if there's evidence that conflicts with that position, credible evidence that conflicts with that as to the reason why she's being terminated, then that's a jury question, and that's kind of the whole argument that your opposing counsel's making, right? I mean, certainly, as you didn't point out, there's evidence that if you went to a jury and you presented, the jury said that, we buy that, and you win on a jury trial, then that's why we have jury trials.
Well, Your Honor, I would respond and say it's all about the timing of the proffering of the evidence. Again, prima facie case, burden of production, shift it back, poke a hole, introduce evidence in the record at summary judgment as to why there is a question of pretext.
No, I agree, that's the standard. And she's saying we did.
I'm sorry?
She's saying we did, you know, this is not credible stuff that the CRC is relying on, these June 14, 2010 or 2016 document, and the one the following June 22, 2016, that there's reasons to not believe that, and therefore, that's why we have juries and we don't let judges just summarily decide it.
Well, Your Honor, I would say that again, we're at a hearing on a motion for summary judgment. The standards are what they are. The shifting burden analysis is what it is. The judge made a determination based on the totality of the record, everything that was proffered, and determined quite correctly, I would add and hope, that there was no illegitimacy to the proffered rationale for termination.
So did the judge say he was construing things most favorably towards Ms. Peoples as the non-moving party?
No, I don't believe, Your Honor. That's not what the record reflects.
Isn't that what he's required to do at the time?
I'm sorry?
Isn't that what you're supposed to do at the time?
Yeah,
I don't know whether you have to announce it, but you know, if that has to be the basis for the summary judgment that you as the non-moving party have, you know, I'm construing the evidence in favor of you and you still haven't presented enough evidence to allow it to go to a jury, and therefore I'm ending the case.
You are correct, Your Honor. I misunderstood your question. That is exactly the case. And again, I believe that's what the court did. I mean, the court recognized the fact that, you know, you go to the Goggle case, it's 11th Circuit case, it talks about, okay, all right, here we have this evidence. We have this evidence, these documents that reflect that there was a decision or a concern with regards to the productivity, which established a non-retaliatory action for the termination, but also with regards to what the employer concluded at the point of termination is really in the absence of some taint that, for example, Your Honor, if I were to create a rationale that wasn't true and to justify the termination, and you could establish that as summary judgment, well, okay, that's great, because again, that would be illegal.
That's what I was asking about earlier, that if there was evidence that had been presented in the record that's saying, well, okay, you're saying you're terminating me for not being productive. If you compare me to all the other similarly situated alcohol counselors here, I'm actually the most financially productive for you, so this reason you're giving to terminate me is false, and therefore it can go to a jury, because now I'm being fired for reasons that are only related to why I'm complaining about what you're doing to me by transferring me.
No, Your Honor, I would respectfully disagree with the court.
It seems like I'm giving you questions that are helpful to you, but go ahead. I know I'm missing it.
What I'm trying to get at, Your Honor, is the fact that if the conclusions that the employer drew with regard to the purported reason for termination were fraudulently or purposefully created so as to support the termination, and the employer knew that, then that's not legitimate. But if the employer engages in a process and comes to a conclusion that termination is appropriate based on all of these considerations, then there's nothing wrong. Even if the employer is wrong in that regard, there's nothing illegal about it. It's up to the plaintiff. It's up to the plaintiff at that point to establish that You can't just disagree with the reason for the
But that's
termination.
what I'm saying here. I mean, if you're telling her she's being fired because she's not productive.
Right.
And that's a legitimate reason to fire anybody. So, it's costing me more money than to keep you here because you're not making any money for us. And she says, well, wait a minute, I'm very productive, and she presents evidence in the record that shows that similarly situated employees of hers in the same job are less financially productive than she is, and you're firing the most financially productive mental or alcohol counselor, then that would suggest that your reason is false, and that would be a reason to suggest for a jury that is a pretextual reason, and that you're firing me because I'm difficult or I'm making a complaint. That would be actionable, I would think, and your position was that,
No.
yeah, but they didn't. Oh, go ahead.
No, I apologize. Again, I misconstrued your question, Your Honor. If that were the case, that would be correct,
And
but...
she didn't do that.
She didn't do that. That's
And
correct.
That's why you think you should win.
That's exactly right, Your Honor. There was no evidence proffered by the appellant to show that there were other people more productive. That's simply not in the record. Moreover, as is established by the record, the productivity issue, although she she said, all right, I'm not productive, but I got a great DCF audit. Well, that's a qualitative analysis. Oh, that's great. That's wonderful that you think that, but that's not the stated rationale. That's not our criterion for evaluation of performance, and we're the employer, and we have a right to do that.
I mean, I could look at my staff attorneys and say, you prepare great memos, but you prepare one a year. I can't have that. I have to have more. Therefore, even though you're a heck of a writer and you're just not cutting it for me because I'm falling behind, so I'm terminating you. That's qualitatively they may be very good, but productively it's not meeting with and not for my benefit of Emily and Brad. I'm not saying that about either of you or my staff attorneys today. But,
I would agree with Your Honor. Thank you very much.
Do you, you also made the allegation your client did that that Ms. Peoples was unprofessional and was exhibiting conduct that was unprofessional. What is, I look at it and I think part of it could be her interpretation of a lack of response by CRC as being the reason why you have this email that comes out. I think it was the August 8th email. But please speak to that. What is the actual unprofessional conduct that you're making the accusation about?
The record reflects, Your Honor, that Ms. Peoples had spoken to other employees saying that this was not a good idea. I am going to build a file. I am going to claim that the workplace is not safe. I am papering the file. I will plan on suing CRC.
is there affidavits from those people she allegedly told, or is this just some hearsay document created by CRC?
It's reflected in the testimony as attached to our motion for summary judgment.
Whose testimony?
I think it was Halima Scally, who was the individual who was responsible for kind of doing some field training with Ms. Peoples.
She said that she heard Ms. Peoples say that, or that's
Yes.
her belief?
Yes. No. I'm sorry, Your Honor. Yeah, so moreover, what else was there? Again, there was a threat of lawsuit. It was criticism of the senior leadership, Mr. Gaffney, and his son, Mr. Gaffney Jr. So the record establishes pretty clearly, Your Honor, that the conduct did occur, and the law is pretty clear that the employer does not have to abide by it or to tolerate it. In fact, I think the record reflects that it was Dr. Seymour, who's now deceased, who said, listen, I understand this is a sticky situation. I understand that she has been threatening us, but we cannot tolerate this. Our operations are suffering. And, Your Honors, that's all my time.
Thank you.
Thank you.
Counsel, you've got 2:42. I'm going to give you another minute based upon my questions, so give you a little short of 4 minutes. Okay?
Thank you, Your Honor. If there is any evidence in the record from which a jury could find that the reason Ms. Peoples was fired was that she complained about the lack of training and qualification for the position or the lack of safety, then summary judgment must be reversed.
Is that right? I mean, let's, if there is, she's the one complaining about it. But I mean, their position is, hey, you've already, before anything ever came up about you being transferred, we were looking at terminating you for your lack of productivity, and that's the reason we're doing it. You may think we're doing it because of the improper retaliation, but I mean, even if there's some whiff of improper retaliation, if there's still the legitimate reason, non-discriminatory reason that has not been countered sufficiently, it's a but-for standard.
Yes, Your Honor.
Okay, so
I'm not contesting that.
Okay, but I mean, so in other words, if they walk together and you don't rebut the fact that there's a legitimate non-discriminatory reason to do that, why is the judge not correct in granting summary judgment, saying, you know, you haven't told me why they weren't going to terminate you anyways because you weren't productive? That's been on the table. There's no counter evidence under the new 1.510 rule. I got to go with it.
Your Honor, my argument is that there is counter evidence.
Okay, what is it?
There's a multitude.
Give me your best multitude of it.
My best. It's a little hard
Whatever's
to
the
say.
one that would be the one to be convinced the jury, that would be the greatest thing for them to say, yeah, boy, this is pretextual.
The handwritten termination memo expressly refers to the fact that Ms. Peoples had been talking to Gaffney and Goodman, and the record shows that what she was talking to them about was her lack of training and the lack of safety. But there are additional reasons too. Woodward said that the official reason for her firing was poor job performance. If there's an official reason, the jury could infer that there is an unofficial reason that is improper, and that is the real reason. And her most direct supervisor, Ms. Goodman, said she was not aware of any job performance issues with Ms. Peoples.
Is there a difference between job performance and job productivity, financial productivity? My staff attorney does a great memo once a year.
I think
it's not very productive.
Low productivity would be a job performance issue, but remember, Your Honor, that she was not fired when they allegedly raised these productivity issues. She was fired 2.5 months later, and the reason referenced in the memo was not productivity, but was she had been talking to Gaffney and Goodman. And I see that my time has expired. And so with that, I would rely on the briefs and the record and ask that you reverse.
Thank you, Counsel.
Thank you.
We doing the same
All right.
thing?
Yeah. So, Mrs. Lawton, would you please give the students the benefit of your background and how you got to here today, February 21st at the 5th TCA?
I came east on I-10 and
was always interested in the law. I did mock trial in high school and policy debate, and so I think a career arguing was always a natural thought that I had. I went to college at the University of Georgia, majored in English and Spanish. During that time, for a while I was undecided whether I wanted to be an English teacher or a lawyer. I knew people who were teachers at the time, and they were very stressed out by it. Of course, law is also a very stressful field, but I made the decision to go to law school. It was kind of a toss-up. While I was in college, my family moved down to Florida, and so I followed them here and went to the University of Florida for law school. During law school, I learned of the existence of this wonderful job called being a law clerk for an appellate judge. I'd never heard of that before. I don't know, I wasn't here for the discussion after the previous arguments. I don't know if any of y'all have been told what a law clerk is. No, okay. So as Judge Lambert referenced, he has 2 lawyers who work for him. And every judge on this court has at least 2 judges that work, lawyers that work for them, and they look at all the attorney's briefs, they look at the records, they discuss the cases with the judges if the judges want, they do research for the judges, they just assist in whatever way the judges want to use them. It's a great job that a lot of people do as soon as they graduate law school. So that's what I did first at the First District Court of Appeal over in Tallahassee. I ended up staying there for almost 10 years, which is used to be sort of unusual. It's becoming more common, where people will become what they call career clerks. So I stayed long-term doing that, and then after doing that for a while, I got the opportunity to go to the Florida Supreme Court and be a law clerk for Justice Lawson, who recently retired. And then I was there for about 3.5 years, and decided once again to try something new, and went out and opened up my own appellate practice. So all I do are appeals. And that was just sort of a natural transition, and then also I had a good opportunity to do that because in addition to just finding my own work, Justice Lawson had put me in touch with someone he knew who had asked him if he knew anyone looking to do appeals. And so I have like what they call an of-counsel relationship with another firm where I work closely with them in addition to having my cases.
Justice Lawson used to be on our court. He was on the court with Judge Wallace and I before he became elevated to the Supreme Court. He's an excellent, excellent judge. We're sorry that he left the Supreme Court.
We have his picture hanging right here in the
He's
courtroom.
that's why nobody asked that. All these pictures on the wall, we actually added the 5 who left. These are all the judges who have ever been on this court since it was created in 1979. In the far right corner over there, that's Judge Cross. He was one of the people that came up from West Palm Beach for the 4th DCA when he started. He and Judge Douch and a circuit judge from Orange County, Parker McDonald, who became a Supreme Court justice, were the first 3 judges on our court back in 1979. So those are all the 30 that have predated us here. Some just recently that have moved over to the 6th DCA over in Lakeland. So.
Thank you, Mrs. Lawton. And before we get to the students' questions, Mr. Webb, would you like to introduce yourself?
Thank you, Your Honor. My path through that brought me here today is probably a little more winding than most of the lawyers that have appeared. I'm from New York City originally, but that said, my mother's family is all Irish American, and so when I was a kid growing up in New York, you know, we always had the family lawyer because it's like you had your priest and you had your lawyer, right? So, and our lawyer was a guy named Owen Carragher, whose parents were from Ireland as well. And anytime there was an issue, my grandmother would say, gotta call Owen. And he was a solo practitioner in Yorktown Heights, New York, and he was just a great guy. And his son now is retired. But he was always kind of a mentor, just kind of he was a role model to me to a certain extent. And then my father's side of the family, my father was adopted. So he didn't know his family, and he always wanted to be a lawyer, but he was just never had the opportunity to do so because, you know, he just grew up in Florida, grew up very, very poor, and never had very smart man, but never had the opportunity to do it. And he always wanted me to go to law school. And quite honestly, I resisted. I resisted because my undergraduate degree, I went to a small school, Iona University in New Rochelle, New York. I was a history and theology major. And interesting because I think I was attracted to the law because of the historical foundations of the common law, and I think there's a lot of parallels between theology and law as well. So, but I resisted, and I wound up going after playing some music for a while in New York and starving to death. I came to Florida and I got a master's degree in business and finance at the University of Florida, went back to New York, worked on Wall Street for a number of years, and then got tired of that, came back to Florida. I was playing music in St. Augustine, much to the chagrin of my father again, and he said, you got to do something with your life. And I said, all right. So I took the LSAT, and I got accepted to the University of Florida. And lo and behold, I came out of law school. I did fairly well. I was in law review because I had other responsibilities. I'm married, and I had 2 children who were born when I was in law school. But I wound up in Jacksonville, Florida, of all places in the world. So here's this guy coming out of the Bronx, New York, wind up in Jacksonville, Florida, working for Mahoney Adams and Chrysler. Your Honor remembers Mahoney Adams. And this white shoe, blue blood law firm, oldest law firm, continuing law firm in the state of Florida at the time. But it's interesting. Years later, before my father passed away, I had an opportunity. I tracked down his natural family because he had never known them. Turns out, is it nature or nurture? He has a first cousin who is who's a professor at George Washington University School of Law in D.C. and he worked on on the U.S. House of Representatives Ethics Commission for years and years as their counsel. But in any event, went to law school, worked for Mahoney for a while, did civil litigation, and went to I was with another labor and employment law firm for a couple of years, and then had an opportunity to go in-house with a corporation, with a transportation logistics company, which was fun for me because it was more business-oriented. I could put on my law hat with contract negotiations and things of that nature, direct litigation, but at the same time, I had some business skills that lent themselves to application in that context. So I did that for a number of years, and then I was bitten by the political bug, and I ran for the city council of Jacksonville and got elected, believe it or not, and wound up serving as the president of the Jacksonville City Council. And then did that for a year, and then was unceremoniously rejected by the voters in the next election, which is fine, and went back into private practice with another firm until about 5 years ago. I went out on my own. My paralegal Alexis Ritchie and I are here, is here with me. I am a solo practitioner. I have my own clients, I have my own cases. We do a lot of different things, from private equity disputes to employment-related matters to labor contract negotiations to commercial negotiations. So what I really enjoy about the practice of law is the day-to-day intellectual challenge. You are not necessarily pigeonholed. As Mr. Post here is a long-standing member of the Jacksonville Bar, and I think Jim told me one time, he goes, "That's one thing about you, Jack, you're always outside the box." So the practice of law gives me an opportunity to deal with clients, to help people.
So he's Jack out of the box instead of Jack in the box.
So that's me. As you probably noticed, lawyers really like to talk about themselves, right?
Yeah, we're never worried about that when we ask them to talk to students. That I wonder if they could think about things to talk about here.
Thank you, Mr. Webb. All right, we have any questions from the students for either attorney? Yes.
I have a question for you. What's your favorite part about your job?
Coming to the 5th DCA.
Well, oral argument is actually a really fun part. But I think, as Judge Sal was saying earlier, the opportunity to stick up for people, express some information with the use of my knowledge in the law. It's probably really fun.
I have a question for you.
Sure.
What's your favorite case that you've been in?
I'm sorry, my favorite case? Well, probably one of my favorite cases is one I can't talk about because we settled it yesterday and I'm subject to a strict non-confidentiality provision. But I honestly, aside from that, all joking aside, I would say, I guess you'd have to define favorite, and most challenging probably is one that I've had going on since 2017. We are now in 2023. We filed suit in 2017. We got pulled into a bankruptcy proceeding in New York, in the Southern District, Federal District Court, Southern District of New York. It was reversed, remanded, motions to dismiss, motion to convert into summary judgment, discovery, briefing, and it's still ongoing. Now, the reason that would be my favorite case, because it draws upon all levels of experience. Again, not just the law, not substantive law, because you've got the substantive law, what's legal, what's not legal. Then you've got the procedural aspects of that, both on the trial court level and on the appellate level. So the procedural aspects of a case, in large part, drive the substantive argument. So that's a challenge as well. And then you've got application of very complex business concepts on top of that. So it forces your brain to ping on all levels, and so I would describe that as my favorite case.
All right, thank you. Is there any other student that has a question? Yes, ma'am.
I have a question for both of you. What strategies do you typically use when researching a case?
Sorry, what was your case?
What strategies do you typically use when researching a case?
So when I think of research, I'm assuming you're researching like what law applies to the case? trial lawyers have often done a very good job of identifying what the legal issues are, and they give you a great starting place. A lot of times they've even already started citing cases and statutes that are relevant. And so, you know, if there's a statute that applies or a constitutional provision, I start with the language of that, and, you know, figure out what the meaning of it is. If it's not clear, I look up the words in the dictionaries, and then you can also look at cases. And I say you can look at cases, you may not be aware, but we lawyers have this great tools, these great online tools that we can use to research, called Westlaw and Lexis. Are you familiar with either of those? No. It's just this electronic, it's a website you go to, and you can type in keywords like you do when you're doing a Google search, to just find new cases on the area that you're interested in. And really, you can take your research a lot of different ways. So that's one way. If you've already got a statute or a constitutional provision that you're looking at, you can go to Westlaw or Lexis and plug in some keywords and find cases on that topic. And these things are very sophisticated. In addition to that, once you find those cases, you can look at, there's a way within that system to find cases that have talked about those cases. And so you can just follow the research trail until you start seeing the same stuff over and over again, and then you know you're done. If you don't have much of a starting point, say you don't know much about the area of the law, we have what's called secondary sources, which you can also access through Lexis and Westlaw, or you can go to the library and look at some of those books that are in there.
You should
And these
write this
secondary
down.
sources will be like, you can just look up a topic. Like some of the, let's say there's one called Florida Jurisprudence, and so it's all about Florida law. So you can look up landlord-tenant law, and they just go into the basics, and they list cases that talk about landlord-tenant law, and so then you can take that and go to Westlaw and do some more research that way. Occasionally, I even use Google. I remember as a law student, I didn't think about Google because when you're in law school, they really focus you on like Westlaw and Lexis and these secondary sources. But sometimes when you hit a dead end, you remember that Google exists, and then you can find materials there where people have written articles that talk about that area of the law. And then once you do that, once again, though, they're usually citing cases like judicial. When I say case, I mean an opinion that a judge has written about the area of the law. And once you get those cases from your Google search, potentially you can go back to Westlaw and Lexis. So, yeah, and just so you know, when I'm citing a judicial opinion that's been written by this court, if I'm in this court, then they follow that. But if I'm arguing to another court, like the court in Tallahassee, called the First CCA, if I'm arguing to them, they don't necessarily follow what this court has said, but they can consider it and be persuaded by it.
Would they?
So the question is,
Okay.
what's the strategy? You know, I will say this, it depends. That's what every lawyer says. It depends. It depends upon the case. It depends if I'm representing the plaintiff. It depends if I'm representing the defendant. It depends if I'm...
The plaintiff is the one who does the suing, right?
Sorry, Your Honor?
The plaintiff is the one who does brings the lawsuit.
That's correct.
They're the one that's unhappy about something. So Ms. Peoples, because she was fired, she's unhappy, so she was the plaintiff, and so she sued Mr. Webb's client saying, "You done me wrong."
So it's a kind of different dynamic. If I'm the plaintiff, I'm stating the claim, I'm trying to justify to the court why I was wrong in this particular situation. She's trying to demonstrate prove to the court why I was wrong, and on the other hand, I'm playing defense. I'm saying, no. So, like even here today, it changes your strategy with regards to preparation. Like I'm looking at, prior counsel, Mr. Kunde, she had this outline. I'm like, wow, I wish I had one of those, right? I mean, because again, it's kind of like, I have no idea where the court's going. I think I do, but I mean, and again, I'm not a linear guy. I'm more of I'm kind of more of a verbal person, so just kind of get a feel for it. So that drives it. But I will say the one common factor is whatever the strategy is, the goal is to what's best for your client. So if it's this, it's one thing. If it's a criminal matter, it's a different thing. So you have to deal, and the commonality is you got to know the facts, you got to know the law, you got to have attention to detail, and do what's right for your client. And don't, and again, manage your client, not control your client, but always manage your client and always have them have reasonable expectations. That's what I tell people all the time. I tell those clients all the time. I said, your lawyer can be disappointed, your lawyer can be angry, your lawyer can be sad, but the one thing you never want your lawyer to be is surprised. I'll leave it at that.
Thank you. All right. We are adjourned for the cases. I've invited our court marshal and our clerk of court to come here and just talk to the students very briefly before we go to lunch. The lawyers, we thank you for your arguments. We're concluded here today. And yes, so we will be in recess, but students stay put for a second, okay?
Thanks. Nice meeting you. Thank you all. Nice meeting you. Hope you enjoy it. Yeah.
Oh, interesting. I've never heard of a public high school, or was it private?
No, it was fun. It was interesting.
Really? I've never heard of them offering those.
Really?
Wow. That's surprising. Awesome. Okay. Well, thanks. You're welcome. Yes. Ooh, that's a great question. Which one did you guys like best? I'll say the first. Yeah, I liked the first one best too. I think that was really interesting. I think it has an interesting premise. I know that was my Which one? It's both. Here you go. Third. Oh, the employment case.
Who thought it was a little dry?
I did not.
Kind of dry?
Y'all, your banter makes it super fun.
You know?
To sit to hear both sides and all, maybe there's just missing pieces to really resolve what's going on. Still, to take into account
They all traditionally have something to argue. So, and by way of introduction, this is Ms. Sandra Williams, who is our clerk of court. Ms. Williams before was a longtime clerk here on the court. I don't know how long? 17 years as a clerk for working for the judges in the judges part of the courthouse. So Ms. Williams is a lawyer by education. She is licensed to practice law in the state of Florida. And so I will let her talk about her duties as clerk of court, and then we'll have Marshall Soltz talk to you all as well. But first, Ms. Williams.
Okay. Now, do any of you have any idea what the clerk of court does?
I know I can use it to search official records.
Okay.
I do that.
So I like to say we're the face of the court, because if you mail anything to this courthouse, it comes to the clerk's office. If you file something, it comes to the clerk's office. If you attempt to mail something to a judge, it will come to the judge allowed to get correspondence from litigants. So we screen, basically. Anything that's filed, we look at it, we pretty much queue things up for the judges. For example, if you file a brief and your brief doesn't meet the requirements under the rules, we reject that. Say, try again. And when they get it right, we will accept that and accept the brief from the other side. We'll accept the record. And if the record isn't correct, we'll sometimes send it back to the lower court clerk's office to say, hey, you didn't send this other stuff in here. Make sure you get it all in and bring it up, because if we don't, they will get it and they won't have what they need to decide the case. And then they will typically call me and say, hey, get the rest of this record here. We get the phone calls. We're sort of your customer service people. When you call and you say, my brief is due tomorrow, and my dog ran away, and my cat ate my brief, and what should I do? Calm down. You need to file what's called a motion for extension of time. You get that in today, that's fine. Don't worry. So we do that. We get a lot of pro se litigants. Pro se meaning they don't have attorneys. So they ask a lot of questions on what's the procedure for this. We can't give any legal advice. We can't tell you what to file other than file a motion asking for what you want. And it needs to be signed, it needs to be this, and it needs to be no more than this number of pages. Other than that, we try to help you to get what you need.
And money. You also
We
accept
take
the
the
filing
money.
fees,
Nothing passes without getting the funds.
which can be a sizable amount of money annually. So,
Yes.
which is a big responsibility to maintain that too, because it doesn't belong to our court.
No, we have to send that up to Tallahassee. Now, most of our funding is electronic, so we get very few checks or cash. But sometimes people come into the counter and they want to pay by cash. We'll take that. Obviously, give them a receipt and deposit it in the bank and send it its merry way.
So, born and raised, where you go to school?
You want the long story? I'm from the Midwest, Indiana in particular. I went to school at Purdue University, college, undergrad. Then I went to University of Wisconsin Law School, so I'm a lawmaker and a bachelor. From there, I went back to Indiana, and my first legal job was for a medium-sized city. So I was in the city attorney's office, and I was handling administrative hearings and code violations. For example, we had the regulation that if you own a pit bull or a dangerous dog, and a dangerous dog is defined as a dog that bitten somebody, you have to license your dog. Okay? So if you don't license